Okay. Hi, everybody. This is Jim Farrell. I'm with NAMI Urban Los Angeles. Today's meeting is going to be a class on how to best navigate the legal system. That said, I'm not able to, I'm not an attorney, so I can't provide any legal advice today. Gail Evangueletti is also going to be with us today. She's having a hard time logging on, so rather than keep all of you waiting, we're going to go ahead and start the meeting, and she'll join us as soon as she's able to get her internet up and flying. Want to share with you that this meeting is being recorded. So consequently, if you speak at any point in time during the meeting or towards the end of the meeting, please do not use your family member's name, because it would be a violation of HIPAA laws because it's coming from NAMI. So please don't mention any names. You could say my daughter or someone I know, or however you want to phrase it. So that being said, I'm going to go ahead and ask Israeli to start the presentation. Again, this is from NAMI Urban Los Angeles. At the end of this presentation, we sometimes will ask people if they want to send in a donation, because there's several things that have to happen to put on these meetings that it takes some money, but we don't want that to happen if you're not in a position to do that. So that'll probably be our last slide. Just a heads up, we are a nonprofit. Okay, this is our first slide. And this is a photograph that Gail decided to have as a header to this presentation. It was actually a sign that was on one of the hospitals, mental health hospitals, that she had to go to visit someone. And she took this photograph, and it's been a kind of an icon for this presentation. So if you will, next slide. Okay. Again, this is the presentation. Gail will be joining us shortly. I'm Jim Farrell. We're also going to have Louis Leva from the Department of Mental Health Public Guardian's Office, mental health supervisor, that LPS meaning the mental health part of the conservatorship process. And also with us, Linda Boyd, who walks on water. I swear she does. She's also the Department of Mental Health supervisor with assisted outpatient treatment programs. And then, of course, we're going to have Los Angeles Police Department's supervisor with the SMART program, and that will be Diana Hammond, who is the senior MHC RN. So don't ask me what that means, and let's ask her what that means when she presents today. So next slide, please. Okay, I'll leave us up for a little bit. There's always questions at the end of these presentations. And I just want you to be aware of the fact that Gail and I and Linda and Diana and everybody else puts their information out. You can write down these phone numbers. We'll bring the slide up again at the end for everybody. So feel free to do that. This is Gail's cell phone number. She happens to be here in Los Angeles at the moment. However, she lives primarily in Florida. So please keep in mind if you need to call her. And she kind of represents most of the Los Angeles areas. She's very knowledgeable about all the different key contact points and resources. And if you're in crisis or have a question about LPS conservatorship, this is her cell phone number. And just keep in mind that they're, I think, 3 hours ahead. So if you call her at, 7 o'clock at night, it's really 10 o'clock and she might be sleeping and she won't be happy to get your phone call. But this is my cell phone number as well. These are personal email addresses, and you're welcome to call us at any time. And any of the other ones you see here, we'll have that on, as I said, later. Maybe I'll ask Israeli to come back to page 3. So next slide, please. This is something that Gail really promotes, and that is that she wants people to become aware of the different mental health laws that are out there, something that I need to actually strengthen myself on, and to vote. Research what different politicians represent and find out the politicians that are actually advocates, and be an advocate yourself. and get involved and reach out to your elected officials and encourage them to support various measures that deal with the behavioral health industry. Next slide. So we're going to talk about LPS conservatorship. There's several different types of conservatorship. There's probate, which is more focused on individuals born, let's say, with a Down syndrome or developmental issues and that type of thing. And those are probate conservatorships that are very involved, takes a lot of training to learn how to do that. Here in Orange County, where I am, the courts have training programs for that. So you call the public guardian's office and ask for the probate officer of the day, and they will connect you to that need. But for mental health, you can call Gail and I or the Orange County public guardian's office, and they'll probably send you back to me. So the key point of having an LPS conservatorship is the medication. So many times people are stabilized with their mental health and doing fantastic. They go back to work, everything's wonderful, they have an income going, I can't be talk straight, excuse me, but at some point in time they're doing so well that it's not uncommon for people to come up with a solution or a conclusion that I'm okay. I don't need to keep taking these medications, and they go off. If they're on an LPS conservatorship, the courts will not allow them to go off their medications. And actually, you as the conservator have the legal right, the same rights as a police officer or anyone working for the Department of Mental Health, to put your loved one without question directly into a mental health facility, hospital. And the problem is, how do you get them there? And that's where the challenges start when we're trying to get law enforcement agencies to support us in that endeavor. And they're gun shy about doing that nowadays. They do not want to assist in, at least here in Orange County and many other parts of the state and country as well. So it's getting more and more challenging. But the whole essence of that conservatorship is to keep them stabilized so that they can have the life that they're entitled to have. And with that, I won't belabor it. I won't drag it out any further. Next slide, please. As Gail says, everybody has the right to be well. LPS conservatorship is an involuntary treatment, meaning that you don't need their permission to get them into treatment. In Australia, we've actually had a case where one of the families here in Orange County's son, who is an avid lifelong surfer, heard that they're going to have great surf in Australia, packed up his board and took off, and nobody knew where he was. And he decompensated while he was in Australia, and he was, clearly suffering from psychosis when he was on the streets. And they just picked him up, took him in the hospital, and gave him a shot. I mean, that's it. But that's not how it works in this country. They have rights, and their rights need to be respected. But nonetheless, it is an involuntary treatment. It's a great tool, it says, for treatment, which gives the person the greatest opportunity you can't talk today, forgive me, greatest opportunity to regain their life through recovery. And I concur with that, with Gail. Next slide, please. So one of the things that you'll want to do as a conservator is to acquire resources, find out what you can about SSI, SSDI, Social Security, and VA benefits. You'll want to look into Medi-Cal and Medicare or private insurance. These are all things that will help you take the best care for your family members. I'm sorry, I got distracted there. I had an alert come up on my screen. But don't try to use your own private personal money to pay for their hospitalization or their board and cares or their medications. It will bankrupt you. It will bankrupt. And I'll never forget, I was at one of Gail's live meetings in Los Angeles at one of the hospitals out there. And primarily, there was a gal that came on and talked about the fact that they had spent all their retirement funds trying to get help for their son, and put him through all the programs that everybody kept saying he needed, and it didn't help the son one bit, and their money for retirement was gone. And so don't do that. Get and we'll be talking a little bit on how to get set up with Social Security and Medi-Cal and so forth a little later in the presentation. Next slide, please.
Oh, sorry, you went mute, Jim. If you can unmute.
Thank you. I swear I didn't even touch the computer, so I don't know why that happened. I'm innocent. Forgive me. So I'll start over again. I don't know where it cut out. The SSDI and Medi-Cal, Medicare are things that you want to apply for immediately when you become a conservator. You want to establish a date for payments. Just know that when you sign up for SSI, primarily that takes a period of time for those funds to be approved. But when they are approved, even if it's 8 months later, when it is approved, you'll get the monthly payments based on the date that you first applied. So that will come through to you, and you'll be able to handle everything going forward and pay back any monies that you had to use your credit card for, you might say. So ask Social Security to help you fill out forms. When you are a conservator and you go into Social Security, the last thing you want to say is that you're applying for Medi-Cal, and can they help you? Medi-Cal is usually granted when SSI is granted, or they'll give you an emergency Medi-Cal. But you can go in there and say, there's forms to be filled out, and you say, I'm having some trouble filling out the forms. I was wondering if you could assist me with some of the things on the form that I'm not understanding. Can you help me fill out the forms? But if you just go in and say, I'm applying for Medi-Cal, they're not going to work with you on that at all. Medicare is usually granted 2 years after receiving Social Security disabilities. And I'll talk a little bit about Medicare and in general. Basically, if somebody has Medicare, it pays for everything. And it's interesting because there are programs that require private insurance. And I'm going to talk a little bit later about Medicare Advantage and how that works, because that's something that I'm learning about and going through personally at the moment. So we'll look at that a little bit down the road, downstream. Next slide. You want to start off this whole concept of applying for a conservatorship, and that effort should take place when your loved one has decompensated and needed to go into the hospital for stabilization, and while they're in there, and only while they're in a designated hospital that treats individuals for a mental health issue. That's the only time that you can apply for it, other than Los Angeles. Los Angeles also has an outpatient conservatorship process, and Lewis is going to be talking about that a little bit later, so I'm not going to cover that at all. But you want to put together a mental health history so that when that's presented, it was Carla Jacobs who wrote AB 1424. And it says that because mental illness ebbs and wanes from day to day and sometimes from minute to minute, when they're being assessed from their mental health stability, that they may present well at the moment. And it's imperative then that the history of the individual, the list of hospitalizations and other things that would let a doctor know and understand that your loved one's having a real difficult time keeping themselves stable. You want to put it together, but you don't want, 10, 12 pages of mental health history and a bunch of stuff from hospitals. So we're going to show you how to put that together in a very concise way that really sends the message to the doctor, and he can immediately grasp what's going on. And The doctors oftentimes have 20, 30 patients to assess in one hospital. They're hired by the county and they have to move on to the next hospital. And they don't have time to look at a bunch of paperwork. So we're going to teach you how to do that, and it's very effective. Next slide. This is the format that has been a winner. This is something that Gail put together, something that I've utilized now for the last 10 years in Orange County. And when I had live meetings at the Christ Cathedral, I had parents coming to all my meetings, and they would share with me, Jim, of all the documentation, all the training that you've ever given us, this mental health history format has been the most helpful item that you've ever shared with us. That being said, this is not only critically important when somebody's assessing your loved one in the hospital, but when the CAT team comes, you'll want to use it there. When you're applying for SSI, you'll want to use the same mental health history there. If your loved one gets in trouble with the law and they basically have committed a crime while they're not stable, you'd want to show this to the public defender or your private attorney, either one, so that they can present that to the courts and go through a diversion program. It's a really powerful, very important document. And if you have any question on this, Gail and I can certainly reconnect you. And it's also up on the NAMI Urban Los Angeles website. If you go there, you'll find a lot of this information. It's a great resource that they put together for us. Next slide. Really important that at the bottom of that history format that we just looked at, you want to list any allergies or medications that they shouldn't have. For an example, some people are allergic to Haldol, and it causes their tongue to swell, and it can cut off their airway. And so you need to let the doctors know that, because some doctors love to give Haldol, injections. Any kind of thing like, do they have asthma? Well, they should know that, what sort of medication works best for their asthma as well. And I would also include down there the name of the primary care physician and psychiatrist. If they have any problems, again, diabetes, heart conditions, I just mentioned asthma, these are all important things to have at the bottom of your history page. And you want resources available such as SSI and Medi-Cal as well. Gail, welcome aboard. Everyone,
Thank you.
I'm sure they all know you, but nonetheless, she's here, folks. So.
Well, thank you. I've been listening to you, and then Araceli just told me to unmute at the bottom. Usually that stuff's at the top. My computer is going crazy today, and I have no idea what's wrong. So I had to switch locations and a whole bunch of other things. But anyway, that's just all a bunch of other stuff. But Jim, I'm enjoying this. Go ahead. By the way, everybody, today is Jim's birthday, but he doesn't want to recognize it as a birthday. So he has gained another year of wisdom, which he's sharing with you.
I can't believe it. At my age, I have a few hiccups, but, physically, arthritis, of course, we all get that a little bit, but I don't feel that old, but I'm thinking, my God, another 2 years, I'm going to hit 80. Are you kidding me? It's like, what? How did I? No,
but now you've given away your age.
That's all right. The thing is that I think families have, especially for the people that might be with us today that are new to the game, that you have to know that mental illness does not go away. And the type of information that you're hearing today is so important for you to hear. Thank goodness for Gail putting this together in NAMI Urban Los Angeles, because it's just a real godsend. Between this and conservatorship and everything else along the way, it's enabled me to provide the best care for our son. And I haven't given up on him, and he's really turned the corner in many different ways here as of a very recent. So just don't give up. I can remember when I first had to put our son into a mental health hospital. There was this doctor that was way beyond retirement age. And he said, Mr. Farrell, I want to let you know that the ones that seem to make it with, through their journey with their mental illness, the ones that survive that and do best are the ones whose families don't give up on them. So my only advice to you is don't give up. And I'll just pass that forward to all of you today. So why don't we go on ahead and we'll take the next slide. And Gail, you know for
Okay.
sure, right? So this is mine. We were talking about the mental health history and we got sidetracked, and I apologize to everybody. It's my fault, but I sometimes can get gappy. When you're putting that mental health history together in the format that we just showed you a few seconds ago, this is what's going to go on the backside of this. The whole goal is to try to boil down, the last few years of history onto one single page of paper in bullet points like this, so that the doctor can see the dates of the hospitalizations, and then when they flip it over, it has the symptoms and characteristics. This gives a tremendous amount of insight to the doctor as to what's going on, because as I pre-mentioned, it's very hard because people's mental illness sometimes will kind of pull it back together, and they'll be able to pull it together. And so many people with a mental health history are so doggone smart. And it's really hard for the doctors to make a proper assessment. And this is vitally important. So they can see this is what the families by law are entitled to give to the doctor. And it allows them tremendous insight into the needed care of your loved ones. So you put down the types of things, that he or she feels that she's Christ, or she's not, because she's gravely disabled. That's why she's on conservatorship, right? Yet that gravely disabled means that because of their mental illness, they cannot provide for their food, clothing, or shelter. And yet they really believe, as it says here, that they plan to open up chain stores. They're going to make millions of dollars. And paranoia and auditory hallucinations, delusional and believing in all of those sort of things. And the last one, rapid speech. I never really appreciated what that meant until I was inside of a mental health facility visiting someone. And this young lady had befriended him. And I've never heard anyone talk so fast in my life. I thought, how is it humanly possible? Gail said, Jim, you talk so slow. Well, I'll try to speed it up. But you talk about rapid speech. I thought, how can the human brain formulate the words that fast? This is all signs of disorganized speech. And these are the types of things that doctors need to look at so they can best prescribe the right medication for them. Next slide. It's all yours, Gail.
Yeah. Jim's talking about the rapid speech. One girl was asking her parents questions and talking, and they tried to answer and they could. She looked at him and she says, please don't interrupt when I'm talking to me. And that's part of rapid speech. It comes with different things. When you're doing this paper, when you're putting together the symptoms and characteristics, usually that'll be on your second page and part of the third page. The bottom of the third page should be gravely disabled. Don't try and incorporate, I've got evidence, I have to call the hospitals and get all this information. They're not going to give it to you. This is from your mind, from your memory. And on that history, sometimes you have to think back to holidays when things happen. And if you just put a month and a year, that's okay. But in chronological order. Do not say anything positive. It will be used against you. So, and we're putting down things in there like paranoid thinking mother, fathers molested them. That's kind of a common trait. It's not the heightened sexual delusion, heightened racial delusions. The sexual, you can kind of tell whether it's real or not. If they cannot give you details, when it happened, what they were wearing, who was there, or anything like that, if they go, well, it happened, it happened, it's delusional. And when they come out of this state of this sleeping dream that they're in, they may or may not remember it. Racial delusions, they become racial against everybody who's not them. As one young man, he hated Black people. Hated them with a passion. And his mom goes, I don't get it. He's Black. It didn't matter. It was anybody who's not him. They also feel like the government's watching them. But when you're putting these down, you bullet only phrases. Do not explain. Do not give times, last year or this time he did this. Just put the phrases, that's all. And don't give excuses. Don't try to explain and tell what's going on. Be sure to include something, if you can, about the food, clothing, and shelter in your symptoms. They're not safe. They throw food in the garbage because, it's poison. Or you don't even have to say it's poison. Throws good food in the garbage. Destroys a cell phone. The FBI's listening. That's very common. Walking in front of traffic. That's very dangerous. They need the LPS conservatorship. Next slide. These are just other examples. If you give this to the doctor, they appreciate it because in 3 seconds or less, they can tell there's a problem. If they have a question, they can ask you. If you sit there and you try to tell the doctor what's happening, he doesn't have the time to listen to you. So they appreciate this. And if you're trying to get SSI, SSDI, Medi-Cal, Medicare, this also helps them. And when the treating doctor, and we'll go over the process of getting the LPS, initiates the LPS with the public guardian's office, give it to the public guardian. Don't assume people have passed this from one hand to another. Then every time your daughter, son, loved one is in a new hospital or the process is going forward, give it to the people who are handling his case, because people don't tend to pass this on. So you want to be sure everybody gets it. Okay, next slide. Tips. Do not mention substance abuse. Now the law has changed, but each county has until 2026 to implement the law. Our supervisors, in their wonderful wisdom, it says, okay, we're not going to do it till 2026. And when it does change, they changed the definition for gravely disabled. I did not put that in here because I don't want to confuse you. I want you to work with what is happening today. So when you talk about substance abuse, and marijuana is honestly one of the most insidious of all the drugs that they have, it calms their voices, but then they get more and more agitated as time goes on, more irritable, to the point they become violent. So that is a horrible, horrible substance abuse. What you say to the doctor or to anybody when they bring up the topic, I am sure because of their mental illness, they are self-medicating. End of topic. Don't discuss it. When they go to the hospital, they know what they're on. They run a test. They know exactly what they're on. But you build up mental health and gravely disabled. That's all you have to do. All the other stuff is insignificant. Don't mention violence. If they've hit anybody, don't put that down. Put they're highly aggressive towards the mother, the father, people on the street, whatever. And that's it. If you start saying, well, they beat the crap out of somebody, good luck getting them into a treatment facility. Nobody wants them because now they are a liability. So do not say that. Do not say they can come home. Presently, the way the definition of LPS in the state of California to get the involuntary mental health treatment, the LPS, they cannot provide for their food, clothing, or shelter. But if somebody else will provide it, they are not considered gravely disabled. So if your loved one's in the hospital and they're saying, well, we're going to release them at 3 o'clock or 5 o'clock, will you be picking them up? Yeah, you're a good parent. You don't want them on the street. Yes, I will. They say, but I want them under the conservatorship. Well, they don't meet the criteria. The hospital's correct because you said you will take them home. The law is actually, they have to have your written permission that you will provide food, clothing, and shelter. Hospitals don't follow the law. And try to sue them, good luck. You can't, because the law also says When doctors and hospitals release a patient, they are not held liable criminally or civilly. So they can release a patient anytime they want, as bad as the patient is, and they know they are. They don't care. That's just what, because it's a financial thing. And every time the state of California makes a new law that sounds great, pat themselves on the back, how great are we doing? Let me tell you, they've got roadblocks up in front. And one of the big roadblocks that Jim's having to deal with in Orange County and us in LA County is the police will not lay hands on a person. Well, who do you think needs the hands on them to make them get on the gurney or get in the police car? The most serious, probably the most dangerous. Oh no, we're not going to touch them. That's your roadblock. They used to do that a couple years ago. They would lay hands, they would get them in the hospital, no problem. Oh no, that's the new one. So we can pass these wonderful laws, but we're going to put roadblocks to keep from having to implement the laws, which is really sad.
And
Okay,
Gail, can I interrupt just for a brief
please
second?
do, please do.
I'm planning a meeting with one of our Orange County supervisors regarding this very subject. And anyone that's in this chat today that's had this very same problem that Gail just referenced to, please contact me. I would love to get information from you so I can provide it to our supervisors. One family in particular that I've been working with, their whole mental health help really fell apart, and she ended up in a state mental hospital simply because law enforcement would not step in and assist multiple times. And so I'm going to try to put together representatives from the sheriff's department, the police departments, to the supervisors, to you name it, to sit down in a room and say, fine, if the law enforcement has issues with lawsuits and that's why they won't help us, doesn't stop us as a community to do what's right and to sit down and put our heads together and try to come up with an alternative solution to this problem. It's not acceptable to just let it slide like this and let people, rot away. And I'm sorry to say that I've always heard such great things about, especially from the Welfare Institution Code, about how our mental health hospitals are supposed to adequately care for people, and they're not.
No, they're not.
Underfed. They are painful sores that break out, not being addressed by doctors. That's a whole nother issue, and I don't mean to bring that in. I'm just very personally upset by it. But we, as a community, need to pull together, and I'm hoping that this will happen in Los Angeles as well. That the powers to be, the NAMIs, everybody else. Hello, Howard, are you listening? We'll get together and really push for people to get together in a room and say, okay, what are some possible ways that we can explore together to get around this problem? It's not right to let people suffer like this. And I'm sorry, I'll get off my bandwagon. I'm done. Gail, are you done?
Sorry, let me just clarify. You're asking folks from Orange County to contact you so you can submit their experiences to your Orange County Board.
Well, I am, but I wouldn't turn away anybody from Los Angeles as well, because I think that they need to understand this is a broader problem than just Orange County. It's statewide. It's spreading throughout the nation. But they need to understand the magnitude of what's going on and the serious repercussions involved with this, and they need to hear it. And I want to present it. So I won't turn away anyone from Los Angeles. Of course, Orange County has more impact on an Orange County supervisor, but they should get a broader scope of what's going on. I would love it if every county in California were to contact me and send me something I could just sit down on the supervisor's desk and go, here's what's going on. But that's just a personal thing. So forgive me for getting on my bandwagon in the middle of this.
That's okay. Jim's phone number is
Go for it.
714-266-8324. And believe me, he does answer the phone for you. The other problem that we have with the police is if somebody won't open a door, they used to go in to get the person if they wouldn't open the door, if there was reasonable cause. They will not do that. And when Diana Hammond speaks today, I'm going to have her tell you what she was telling me the other day, what was going on. Some of the problem is because when they did the defund the police, if they are being sued, they have to handle that with their own finances, and they can't. And you can sue anybody criminally for any or civilly for anything you want. And the police have to handle that. So their pensions, their future, their job, everything is in jeopardy. We have tied their hands. And that's why, because they used to help us a lot. They were great.
Yes.
And right now it's been very, very difficult. So contact your board of supervisors and tell them you want the police to be covered when it comes to mental health on indemnity, because that way they will cover their finances, their legal finances if there's a problem. Now, that's something that how you feel about it. But if you're trying to get somebody, the people who are seriously mentally ill, who need to be in the hospital, not to wait to go to jail or to hurt somebody, these laws are ridiculous. They're really not laws. It's just how they're implementing them.
Right.
Okay, we'll go on to the next
Let's
slide.
move forward. It's not fair to drag everybody through this.
We're going to run out of time.
Yeah, we will.
Okay. Racial, I mentioned racial, they become racial against everybody who's not them. Heightened sexual delusions. These are common things that run through a person, especially one with schizophrenia. FBI, CIA, other people are following them. They're not ill. You have a problem, but they don't. And I don't care how much you talk to them, how you talk to them. It's been severed, the ability in their brain for them to recognize that they're ill. So when you read Amador's book, who says, oh, this is the way you talk to them, throw that book away for now until they are in treatment. Then you can use the book. You stole their money. That's another common one. You took all their millions of dollars, and why you did that, I have no idea. But, that's some of the things they come up with. But there's plenty others. Next slide. Jim?
So, the current definition of gravely disabled, as the law exists, means that a person because of their serious mental illness cannot provide for their own food, clothing, or shelter. So if they can't provide for any one of those, that's why the word or is in there. It's not and, it's or. If they can't provide for their own food or their clothing or shelter, they're gravely disabled. And if they're gravely disabled, then they're eligible to be put onto an LPS conservatorship. However, that being said, if somebody else can provide for their food, clothing, or shelter in a safe manner, then they will not be considered gravely disabled and the LPS conservatorship will not be granted. So refer food, clothing, shelter to safety or health risk. And, it's just unfortunate sometimes that you have misrepresentation, and I will say it, at the risk of being sued, that the public defender's office put together something that basically sidestepped this, saying that somebody was going to provide them with their food and their shelter. All right. Well, that other person happened to be mentally ill themselves, and they themselves were homeless, living on the streets, and that's where this young lady ended up. So you need to, I think that there should be some accountability in this whole concept that you're looking at on your screen, but nonetheless, that can undermine all your efforts. If they call their friends and say, hey, I want you to come to my meeting and say that you're going to help me with my food, clothing, or shelter, and that you'll be sure that my meds are taken every day. So yeah, I agree with you, Felicia. Anyway, this is the current definition defined. Next slide.
Let me just say something on that food, clothing, and shelter. When your loved one goes to court and he's telling the judge, Your Honor, I can handle this. I can go live with so-and-so. You be sure and speak up. That's their pimp. That's their drug dealer, whatever. this person cannot handle that, because then the judge has something to sink his teeth in. If and we had a case where a fellow went to court. I can handle everything, Your Honor. I can get a tent from the city, live on such and such street. I can eat 5 times a day at the food banks, and I can get all the clothes I want from Salvation Army, which is true. The judge had no alternative but had to release the person. If a family member had been there and said, yes, he can get a tent and live on the street, but he's not safe. He's either victimizing people or he's being victimized. He can eat 5 times at the food banks, but he's lost significant weight from not eating. Or likewise, they could be compulsive eating and blowing up like a balloon, either one. And of clothing, they can get all the clothes they want from Salvation Army, but they don't. They wear their clothes for significant periods of time. Don't say 2 weeks, 3 weeks, or something like that, because then they'll give you an excuse. Just significant period of time. Or they dress inappropriate for the weather. It's hot. They've got a sweater, sweatshirt, hood, building up body heat, health risk. Or they take their clothes off at inappropriate times and places. They don't do this 24/7, but they do it. So those are all health risk or safety. Relate everything to that if you can. And remember, you only need one, but really the courts like to see all 3 if possible. Okay, next slide.
So again, under gravely disabled, shelter. When your loved one's in a mental health hospital, a designated hospital, you tell them that that they may not come back to your house and live with you, that they have no place to live safely, and that they can't handle a shelter or boarding care safely. In regards to food, you want to point out, and again, this whole concept that we're presenting right here is based on the whole process of talking to the hospital, trying to get your loved one into a conservatorship. And these are things that you're going to be telling the staff and the doctor that's within the hospital. So you can point out that your loved one's lost a significant amount of weight. They're paranoid of the food. They think they're being poisoned. They don't want to eat it, or maybe just the opposite of that. And Gail, as she said, takes off their clothes, and they don't have any insight, of course, into their illness. So they stop taking their medication. They have no history of compliance. They only have history of non-compliance. So these are the kinds of things that a conservatorship will help you to stay in control of, so that you can best help your loved one to get their life back. Next slide. So you want to decide the direction of treatment. There's a recovery model. There's a full service partnership. Orange County has a full service partnership, and LA does as well. It's referred to as the Assisted Outpatient Treatment, AOT, and LPS Conservatorship. These are the 3 different ones. So you have the recovery model. We have the full service partnership that provides classes. They provide counseling and so forth. They some, like here in Orange County, also provide substance abuse, relapse prevention, and so forth. And then if that's not working, you might look at AOT. And Linda is going to be talking about that later in this meeting, so I'm going to not talk about that. I'll let her cover that. And the third one is LPS Conservatorship, which is very critically important if they're suffering from lack of insight and not taking the meds. So those are the 3 approaches that you can take for treatment, as well as counseling, psychologists, that type of thing. So next slide.
Let me just say something about the full service partnership, AOT, and LPS. If your loved one's in one of those programs and you're not having success, or things are not working as they should, don't hesitate to go to the supervisors. The supervisors have a lot of teams. And, as with everything, lawyers, doctors, whatever, you have good people and you have people that kind of do what they have to get by. On AOT, Linda Boyd, we are so blessed. She's a fabulous supervisor. If you call her and say, I'm having problems with such and such, she will correct the problems. A lot of times, people who work in mental health will regurgitate to you exactly what they've been told, which may not be true. Linda will correct the situation. She will go back. She wants her teams to do a good job. So she will go back, correct them, educate them, help them, whatever. She's not going to fire them or, really carry on with them. She's trying to help them. If she doesn't know there's a problem, she can't fix it. And it's true with full service partnership. A lot of people call and complain about full service partnership. Go to the supervisor of full service partnership and let them know what's going on. You can't fix anything that you don't know about. And that's one of the best ways to get our people so that they can get services. Okay. Oh, Jim, go ahead. I'm sorry. Use your written piece.
I was just sitting back enjoying the ride. I'd throw it back at you today. I love it. Basically, somebody asked, where can you get a full service partnership and stuff like that? Maybe we'll be answering those questions at the end of this presentation. AOT, Linda's going to be talking about when Gail and I finish with this. So we've talked about trying to obtain a conservatorship for your loved one when they're just not doing well with all your efforts prior to that. So we've kind of presented today the format and how to put a mental health history together and so forth. And you end up with this document that has all the hospitalizations on one side. You're looking at the DSM-5s on the backside in terms of, their false beliefs and so forth. And where are you going to use this document? Well, you're going to use it when your loved one is being assessed on a 5150, or you're going to use it again, not only for the application of a conservatorship in the hospital, but when you apply for your Social Security SSI and SSDI or Medi-Cal. These are very important. This becomes a very important document, I should say, the mental health history. For any of these situations, it really does make a difference when they see what's going on with your loved one and why you're trying to give them these services. When you request the police or psychiatric team to hospitalize the person, well, we kind of touched on that one a little bit, but nonetheless, having that history, I think, is very, very powerful. And unless their commander is not going to allow them to, jump on board to help you, this is a very helpful thing. Has been in the past, becoming less so because of the police's current stance on things. When you're trying to obtain AOT or a full service partnership or a mental health history, this written case of the mental health history is a very powerful document, and it goes a long ways in obtaining these types of services. If your loved one's been jailed because they perhaps have committed a crime or something, you can give this to the social worker at the jail and ask them to give this to the treating doctor. By the way, if they've committed a serious enough crime and they're going to be held in the jail long enough, you can ask the doctor in that jail facility to initiate the LPS Conservatorship. Again, you want to give that written document, the written case as it's being called, to that treating doctor inside the jail. You want to provide it to the public defender when your loved one goes to court for some law that they have broken and have been arrested for. The public defender needs to see that. And, last week, this parent was telling me, oh, I've got such a great attorney. Why, my son was so psychotic and he was going to go to jail, but this public defender, or my private attorney, as a private attorney, was able to get him into a diversion program. Well, anybody could have if they just knew about the diversion program, just about. But in a criminal court for the public defender, if you're using a public defender, absolutely you want that public defender to have their written case and present it to the courts and say, Your Honor, a loved one is suffering from a behavioral health, mental health issue, and was so at the time of the crime. And will you please consider diversion programs in lieu of jail? If you're in a mental health court, of course, anytime that you're in any of the things listed here, this is a very powerful, much needed document. Next slide.
And let me just say something about that, in jail. If you're getting your loved one in a jail diversion program, try to get the treating doctor while they're in jail to initiate the LPS conservatorship. It's almost like an insurance policy, because they have to agree to the jail diversion programs. So if they agree today, but tomorrow they go off their meds, they're right back in jail again. If they're under the LPS, then if you do it early, we can get them in the hospital where the hospital is the only place that can force medications. So we can get them back in the hospital, back on their meds, and they're good to go. So if you can get the LPS and the jail diversion, that's a great combination. Okay. Oh, this is mine.
It is.
Yeah. When you hospitalize a person, there's two ways you can do it. You can call 911, or I think they have a 988 now or something like that. Or you can call the access team. Generally, if you call 911, ask them to bring someone from an evaluator to evaluate them. If you call 911, it's usually because the person is a harm to himself or others, or a flight risk. Do not wait for that person to hurt anybody. We don't want them to be going to jail if it's not necessary. Do not call the police a week after the incident. You have to do it then. Or when they're threatening, you have to do it then. If they're being agitated and carrying on, call the police at that time. Demand the person be placed on a 5150 and taken to the hospital, not jail. When the police come out, usually they're supposed to come in unmarked cars. They don't always do that. Meet them outside, give them a copy of that history, symptoms, and gravely disabled, and ask for their cards. They all carry their cards with their phone numbers and contact information. Go ahead and get that, and then tell them specifically what's going on. Now, a lot of our loved ones they're brilliant, and the police go in there and they're acting perfectly. Officer, it's really not me, it's my mother or my father. They really have a psychotic problem, and you need to take them to the hospital and take care of them. Not an unusual thing for them to hear. And so if you have 3 open-ended questions that can get them going, I know NAMI tells you want to diffuse the situation. No, not necessarily. You might have the police ask them, I understand your mother's taken your $1 million. How can we help you with that situation? Or I understand your father's molested you. How can we help you with that situation? Or I understand that the people down the street they're following you. Or the FBI. How can we help you with that situation? They're not arguing with them. They're not denying that that's true. They're just getting them, and they'll start talking. And once they start talking, chances are they're going to the hospital. Now, if the person is gravely disabled, they're losing weight, they smell because they haven't changed their clothes or something, that's the other way to get them in the hospital. You can call the access team. The access team can take a while to get there. Sometimes they'll say, we're on our way. If it's during a school day and they get a call from the school that there's a problem, they have to divert. The school comes first. So you're waiting and waiting and they don't show up. Call back and say, okay, are they on their way? Then they will tell you that they've been diverted. So when it comes to anybody dealing with mental illness, with the exception of a few people, don't expect calls back. It will increase your stress level. Just always call them. Best time is 8 o'clock in the morning. And if they're in meetings, when will they be out? Set your alarm, your timer. Call them back when they're supposed to be out of that meeting. And just keep calling. That's the best way to do it. So you can get them in the hospital 2 ways: on a 5150 and you ask that they take them to the hospital, not to jail. And that's when they're harm to self and harm to others. Or the access team, if they're gravely disabled, but if they're a flight risk, ask them to bring the police. Now we have different teams and they call them different teams in Orange County: CAT, SMART, PET, whatever. It's usually a combination of a police and an evaluator. And Diana Hammond's going to be talking about the SMART team. She's the supervisor, an amazing person. She really is. She can make things happen. And so I really like her for that. Okay, next slide. The open-ended questions, which I already mentioned. I understand the FBI is following you. How can we help you? I understand your parents stole your money. And I understand you must harm somebody. How can we help you fix a situation? These are all just open-ended questions, not a yes and no question. Next slide. Usually the process that takes place when a person is hospitalized, they're on a 5150 for 3 days. That's known as a 3-day hold or a 72-hour hold. Then they go to a 5250, which is also known as a 14-day hold. Now, within the first 4 working days, and hospitals are now counting the weekend as a working day, they have to have what they call a probable cause hearing or a certification hearing. It's same thing. They hold that in the hospital, and that paper that you've given to the doctor at wherever they are on that 5250, that can help them to be able to keep them longer. Basically, that hearing is we have the ability to keep them for the full 14 days should we choose to use that. Doesn't mean they'll be there for the full 14 days. They tend to release them on day 11. So, but it at least it gets them past that 4 days on the 5250. Then you have an intensive hold, which is a 5270. You don't have to remember all those numbers. The only one you'll probably remember is 5150. It's a 30-day intensive hold. Now, what the time frame and time is of the essence on all of these. You do your 3-day hold, no problem. They go on to the 14-day hold. After that, probable cause hearing, certification hearing is one and the same. That is when, if the doctor is going to initiate the LPS conservatorship, when he will do it. He's not going to do it beforehand, because if they win in the 5250, they release them. The doctor's done all that paperwork. They don't appreciate that. So they will do it after that probable cause hearing. And at that point, you contact the public guardian's office. They'll give you all the information you need for everything. You give them a copy of your history, symptoms, and gravely disabled. Find out who's handling that case and follow along with them. They'll let you know when the person is going to have a court hearing. And there's a lot of other little hearings. I'm not going to drown you in that right now. Once the doctor initiates the LPS, they go on what they call a temporary conservatorship or a TCON, or if you want the numbers, there they are. That's for up to 30 days. That is when the public guardian does their investigation on the person to find out if they meet the criteria for the conservatorship. That paper you've given to them helps them a lot. So this is very important. They also set up so that you have a court hearing, and they have to do everything within 47 days from when the person was first put in the hospital or taken on the 5150 to when they get the LPS conservatorship. It must be done, the whole kit and caboodle, within 47 days. Okay. Jim, you want to add anything?
I think you've nailed it.
Okay. Next. Okay. How to acquire the LPS conservatorship. You don't apply for it. Don't hire an attorney. I mean, you can if you want, but they cannot make the doctor initiate the LPS conservatorship. Only the treating doctor in the hospital or the jail can initiate the LPS conservatorship. They must be in the hospital or in the jail. This is not the law, but the practice. And the reason why, if the person does not show up in court, then the case is dismissed. So their private attorney, private doctor might initiate the LPS conservatorship, assuming they are certified for it, because they have to have a certain certification for it. But if that person doesn't show up at court, the whole case is thrown out. That's why the practice is that for them to be in the hospital or in the jail. Now, in Los Angeles, we have a pilot project called the Home Team, and they're doing a darn good job. If your loved one is homeless, they will go out there, they will engage with them, and they can initiate the LPS conservatorship for homeless people, which is really, really good. If AOT's been trying to work with your loved one and they're not cooperative, they can go to court and testify. They're not working with our program. They need the higher level of care, and they tend to do that for us too. But we have a care court, the Home Team. We're getting more and more programs that are helping the people that are on the street. The problem is it's not helping the people that are in your house. And that's the one you need the help with. Okay. And Orange County has programs too, which are also helping. Jim, you want to make any comments about those programs?
I'm sorry, you got distracted in the chat, Gary. Gail, so which programs are you referencing to? I apologize.
We're well, in LA, it's the Home Team or the care court.
Yeah, I haven't been that involved with the care court or the home team type thing here in Orange County. There are attorneys here that are very, very involved and interested in the care court. I happen to know the gentleman that runs the care court, and if anybody in Orange County needs to have their loved ones seen, or, within that care court, they can contact me, and we're going to put our contact information up. But I can actually provide them the document that they will need to fill out and submit to the court so that their loved one can be seen in that court itself.
Okay.
About that.
All right, next slide. LPS via the hospital, give your written case to the treating doctor in the hospital. This opens the door, it gets your foot in the door. They'll slam the door on your foot, but at least that door is cracked open. Request the doctor initiate the LPS conservatorship, but remember, they will generally do that after that probable cause hearing, which is when they're on the 14-day hold. Time is of the essence. Now, if you've done the 14-day hold and the hospital keeps them for a 30-day hold, within that first 5 days of that 30-day hold, the doctor has to initiate the conservatorship. If they don't, the public guardian will not accept it because they don't have the time to do their investigation. So time is of the essence. You want to start pushing early. All right, next slide.
So LPS via jail. And again, as I said earlier, if your loved one has committed a crime and they're in jail, and that the crime basically itself is because, it doesn't have to be because of the crime, but if they are really in need of being on an LPS conservatorship and they're in jail, you can again ask the treating doctor in the jail to initiate the LPS conservatorship. If they've committed a minor and they're just going to release them in 2 days, it's my understanding that they can't, continue holding them in that jail to initiate it. But if they're going to be in there long enough to go through that whole process of a court hearing, and here in Orange County, we use a forensic psychologist that will, would come out and talk with the individual, because unlike Los Angeles, doctors don't testify in the courts as to the need of a person requiring to be put onto an LPS conservatorship, but rather it's that forensic psychologist that testifies in court. So all of this takes a certain amount of time. And if they're not going to be in jail long enough to go through that process, then you may not really stand a chance. But you want to give the treating doctor your written case. Goes back to what we talked about, the mental health history, you know, under AB 1424. That's your right. And by law, it must be looked at. It must be actually read, and it must be considered for treatment. So give that to your doctor. Request the public defender to ask the mental health liaison to be involved in the case, and ask the public defender to request a jail diversion program. You don't want to see your loved one just go on, continue forward, and go through the system as it exists, and end up just, you know, sitting there in jail. You want to get them help. You want to take these steps that Gail has outlined for you. Next slide.
On that jail diversion, many times if they've completed the program, which is usually 2 years of treatment, many times they will dismiss the case or lower it that it's nothing more than a traffic violation kind of thing. So that jail diversion is really a good program. And when the laws change, which they have changed, but they've not been implemented in LA or Orange County, it will also include substance abuse. Okay, next slide.
All right, and then as we go along here, Gail, we might think about, you know, when this is going to finish, and we have speakers behind us, and we want to keep track of our time, so we just want to be mindful of that. The California Welfare and Institution Code 5008.2 states that the law requires that all healthcare providers shall take your information. I referenced to that. And, you know, the historical course of the person must be taken into account for treatment. Mental health, and this is what Carla Jacobs wrote, mental health does not exist in a vacuum of time. The illness waxes and wanes, with presenting well at times and exhibiting psychotic symptoms at other times. Next slide. So the criteria for that LPS conservatorship then is that the LPS conservatorship is California's involuntary mental health treatment for recovery. You must have both a serious mental illness and be gravely disabled. And as Gail talked to earlier, this whole definition of the law and so forth has changed. It's going to include, you know, addiction and so forth and so on. But for now, this is the law. And this will help the person with no insight into the illness that is non-compliant. It will help them with their treatment and their medication. Next slide. Again, what is a serious mental illness? Is it just because they're depressed or something? No. If they're depressed and it's because they have a bipolar situation and it's severe, yes, absolutely. And schizophrenia or schizoaffective, which is kind of a combination of bipolar and schizophrenia mixed together. Really interesting. There was a doctor once that told me that he felt that the type of behavioral health label that we use if we talk about bipolar or schizophrenia, in his mind, this reference to a different section of the brain not functioning as it should be, schizophrenia being more in the temporal lobes and that type of thing. But these are serious disorders that seriously disrupt a person's life. They can have serious clinical depression, and I'm glad to say that they have new treatments out that use magnetic impulse waves, and I won't go into that at the moment. They may have obsessive compulsive disorder. I've talked to families, and this is such a serious mental health disorder itself. It's just one of the really rough ones. Or they may have chronic alcoholism. Heretofore, even though chronic alcoholism was part of the Welfare Institution Code and they talked about it, you couldn't get anybody to put somebody onto a conservatorship for alcoholism. Well, that's going to be changing down the road once the counties that have deferred accepting the new mental health laws swing into action, then alcoholism will be part of that. Let's move on to the next slide. Thank you. Gail, this is yours.
Okay, the types of conservatorship. The doctor There's two kinds, the conservatorship of the person and of the estate. This is LPS. Now there's probate conservatorship. We don't deal with that. That's for anybody who does not have a serious mental illness. It would be for stroke, dementia, that sort of thing. But the conservatorship of the person, it is the treating doctor at the hospital or the jail who can initiate that. And what it gives you is if you choose to be the conservator or public guardian, the power to approve or disapprove treatment, placement, medication. The conservatorship of the estate. Now, that doesn't mean they're a millionaire and, they have all this money and all that stuff. If they have debts, school loans, criminal cases, ask the public guardian to petition for you to have the conservatorship of the estate. You can run a credit report if they have debts on Credit Karma, which is a freebie or something like that. Find out what their debts are. This way you can work with the debtor to either pay them 10 cents on the dollar, whatever, to have that erased, or after 3 years, if they do a judgment, the judgment is gone off the credit report. So don't worry too much about that. But it is not the doctor's responsibility on the estate. It's either the court, you can ask the court, or you can ask the public guardian, and you don't have to wait. Let's say you get the conservatorship of the person, then you find out they have all these other problems. You can go back to court and request that the court give you the conservatorship of the estate. When you get your conservatorship, ask the judge to appoint you an attorney. They're freebie attorneys, but should you have legal questions during the year, they are most helpful. So you always have somebody that you can contact and say, hey, I need help with SSI or the renewing the conservatorship or whatever. Okay, next slide. That's a probate conservatorship. I already talked about that. For people with other illnesses, usually it's mostly for older people, but younger people can have it too if you have autism, brain damage, other things. Next slide. A conservative's loss of rights. When a conservatorship is granted of the person, this is the essence of the conservatorship. They lose the right to refuse medication. That's the whole essence of it. They temporarily lose the right to enter contracts, drive a car, or to possess and own a gun. Those rights can be reinstated. The right to enter contracts. We had one fellow that went to Vegas and married 3 women in one night. Those were all annulled because he didn't have the right to enter contract. To drive a car, they can get the right to drive a car while they are under the conservatorship. The whole thing is to help them with their recovery. And there's a process for driving a car, getting that right to drive a car. We discuss that tomorrow. And the right to possess a gun, I heard about one person that went back and asked for that right and actually got it. And there was a good reason why. But basically, our people don't ask to get the right to possess a gun. All right, next slide. The right of the conservator. If you choose to be the conservator, there's pros and cons for each. You have the right to approve or disapprove treatment, placement, and medication. If the public guardian is the conservator, they don't normally mess around with the medication because that's not their pay grade, but they can request, and so can you, a medication review. I hate to say it, there are too many doctors that will over-medicate a person or put them on the wrong medication. And just quickly, I'll just say, if you have a headache and I have a migraine and you give me your Tylenol for your headache and say it'll help, it won't even phase my migraine. This is the same with serious mental illness, not mental health. Mental health medications do not phase those who have a serious mental illness. So, and we talk about that mostly tomorrow. Okay, you have the right to work with the doctor to approve or disapprove medications. You also have the right to say where they go for treatment. All right, next slide.
So who should
be the-
actually,
Oh, I'll be quiet with pleasure.
I'm on top of it today, Gail. Sorry about that. So who should actually be the conservator of your loved one? If it's, they go through the court system and the courts are going to grant the conservatorship, who's going to handle it? Is it going to be you as the family member, or is it going to be the public guardian's office? Again, we have the public guardian with us today, so I don't want to get too heavily into this, but it's a decision that doesn't come lightly. If they're with you, you've got all the stress of their demands all the time. Maybe they have a substance abuse and they want you to keep giving them money, and you're afraid they're going to go down the street and find some drugs someplace. It's a lot of stress to deal with. The public guardian, maybe you could go with them. So here are the pros and cons of all of these kind of things. The public guardian is able to place the person in a state-approved facility, and they have, and also if the public guardian is taking care of them, that means you, the family member, are going to have less stress. You can be there to support them however they need support. You can encourage them, give them your love, be there, in any and every way, but you're not the bad guy because you're not holding the money and you're not responsible for where they go or what sort of treatment they're going to be provided with. So that's the positive. The negative is, as a family member, you're not going to really know what kind of medications they're being given. You won't know what kind of recovery process is going on, and you may not even know if they're re-hospitalized and so forth, unless your loved one signs a release of information or something. And I'm not even sure if that's possible if they're with a public guardian, but maybe that Lewis can talk about that one down the road here when he speaks. But you want to work to establish a working relationship with the public guardian's office. If the public guardian is going to do that, while they can't really, because of HIPAA laws and California privacy laws, give you any information about your loved one, you can work with them. Again, just like the AB 1424, where you're able to give them the information, you can work with the public guardians, share with them what medications have worked well, share with them various things that will give them some insight as to how they could actually provide better care and so forth. So kind of pros and cons of things. Next slide. Gail, anything?
No, you covered it very well. Thank you.
So you ask yourself, well, gosh, what's it like? Do I really want to be the conservator? Well, the uptick of that is that, yeah, you can talk directly to the doctor and be part of the recovery process. You can talk about the medications and so forth. And if, in fact, your loved one's going to be placed into a treatment facility, you have the right to go look at that treatment facility. Let's say that they had to be hospitalized or something. You can determine where they're going to be living, if it's a board and care, step down, if it's an inappropriate treatment facility that they're going to be put onto, or if the medications aren't right. You have the right to override everybody else and make the final decision. That being said, if the doctor says, well, why are you rejecting this medication? I feel this is critically important for the recovery. Well, I just don't like that medication. I prefer this other medication. I think it's better. That doctor will probably haul you down into the mental health courts and have a hearing, and he'll stand in front of the judge and say, Your Honor, the parent doesn't seem to understand that the medication that I'm prescribing is what's important for the recovery process. I'm a doctor. I know the medications. I know what it's going to do and not going to do. I know its limitations. The family member is rejecting this medication and won't allow me to provide it because they just don't like it. Chances are the judge will take away the conservatorship from you and turn it over to the public guardian. So you need to learn to work with the doctor and say things to the doctor like, doctor, I've had him on that or her on that particular medication before, and there were some really unpleasant side effects that really kind of hamper the recovery process. And I'd like to discuss those with you, and maybe we could find something that might work a little bit better. Those are proactive steps to take for the treatment of your loved one without stepping on the doctor's toes. Just work with your doctor. That's really what's so important as a conservator that's in charge. So that's all a plus. But what about gosh, what's the downside? Well, they're going to want you to do all kinds of things that in your estimation are not what you should be offering to them. As I mentioned earlier, you know, they want money for all kinds of things that you go, oh my gosh, no. And they'll nag you and push you and insist and demand, and I want it, and they'll wear you down, and they'll play one parent against the other. And yet, you know, so sometimes that can be challenging. Perhaps your loved one's in the hospital at the moment in time. The hospital's trying to push you around, and they say, you know, we're just going to have to discharge your conservative. That's all, or we're going to just shift them over to another facility. Well, maybe that other facility is not appropriate for the treatment that's required for your loved one's recovery. You tell that hospital, excuse me, I'm the conservator. I have the legal right to go to that facility myself and see if it meets the appropriate level of care for the treatment of my loved one and their recovery. And you will not transfer him prior to that. Because if you do, you're in violation of law. I'll do this in the most expedient way I can. Work with the hospital, but don't let them push you around. Absolutely not. Next slide.
Well, let me just add something.
Sure, of course.
Whoever is the conservator, would be it the public guardian or the conservator, it doesn't have to continue for the entire year. If you start out, sometimes it's good to start out with the public guardian as a conservator for a month or two. Then you can request to be the conservator. You just have to petition the court, and it takes about 7 to 10 days to get it done. Or if you start out with a conservator and you go, whoa, this is not working, you can give it back to the public guardian.
Yes.
So you're not stuck for a whole year one way or another. And sometimes it's advisable to have the public guardian first, then you take it over. Now that's in Orange County, if I'm correct, Jim,
Yep.
and LA. Now different counties do this a little bit different. So when you get further up north, they just want the public guardian to be the conservator. Our public guardian works so well with us in LA County. We are blessed. And Louis Leves, who's in charge of it, he does an amazing job. He really does. All right, next slide.
Okay, let's talk about the court hearing. And I need to shift my window a little bit. Okay, in the court hearing, the patient is assigned to a public defender. The patient can request a court hearing with a judge, or the patient can request a jury trial. So put this in focus. Basically, they were 5150. They were put into the hospital. The doctor in that designated hospital concurred that they needed to be actually put onto a LPS conservatorship. And then now the whole thing goes through several processes, and they end up in the court hearing. Your loved one has the right to have the jury determine whether or not they are going to make the final decision as to whether or not he or she should be put onto a conservatorship, or they could ask the judge, and the judge will make that decision. They get to choose between the two, and the judge will ask them, what is your preference? But then also remember that the patient's assigned a public defender. Public defender's not your friend. Don't think that they are. Sometimes, and I'll just bring up something I brought in the last meeting. Sometimes the public defender will call you. I won't tell you not to talk to them, because sometimes you can give them positive information, but sometimes they'll try to trick you. Again, earlier, remember the part where I said, if somebody else is going to provide help and service to your loved one, then the conservatorship will not be granted. So they say, oh, you know, Jim, just in case the conservatorship isn't approved, will you take care of your son, and will you provide for his food, clothing, and shelter and so forth? No. And they said, no, because if I said, well, if he didn't get the conservatorship, of course I'm going to be there to help him. Oh, then he has somebody else that's going to provide food, clothing, or shelter. he's not going to meet lawful requirement to be put onto a conservatorship. So you want to be very, very careful about ever talking to a public defender, what they ask you and how you answer to them. And if you have any question at all and you're not sure whether you should answer the questions, you can say, I'm going to call you back after I talk to Gail and ask if this is a question I should even answer. So, don't let them push you around. But just know that they do have the right to a court hearing. And of course, the people in the court hearing, the jury trial is what I meant to say. They may not be that really understanding of mental health and what it involves, and may look at you look at your loved one while they're in the trial and say, gee, he seems pretty good to me.
Jim, we got the notice from Araceli. We have to speed up. But let me just say on the public defender, if it's criminal, you want to talk to the public defender for criminal cases, but not mental health. Okay.
No more ad-libbing. We'll go forward. Move along.
You got to speed up.
Next slide, please. Gail, it's yours.
Mental health court is Department A. This is where it's at. It's Superior Court. It's in Norwalk. We have Judge Heron, and he's wonderful. We've had bad judges that they learn every time they switch a judge, they have to learn on the go, and they're not always very good. A lot of people, some judges don't believe in involuntary mental health treatment. Judge Heron listens. He's excellent. Next slide. After the LPS is granted, the hospital should hold your patient until a proper facility that's appropriate for their care is located. They should request the intensive care division to evaluate the patient for placement. And the paper, that LPS paper, somebody asked about that, if they could get a hold of that. Let's see. NAMI Urban LA has it on their resource numbers, and I suggest that you get that and download it or email me. Just put in subject, send LPS paper. I will. Best thing you can ever have, and be sure it's not in a PDF, but so that you can copy and paste whatever it is you need on that. Okay, the level of care is determined by clinical recommendation. It could be an IMD, but as a person's recovering and the medication's working, they may not need the IMD. That's an Institute for Mental Disease. It's a lockdown treatment facility. If you are conservator, you have the right to tour all IMDs and make a decision what you feel is best appropriate for your loved one. The next level would be enhanced residential setting. If the medication's working well for your loved one and they're really starting to get it together and they're not a flight risk, they can go to an enhanced residential setting, which is a secure facility. And that helps. Next one would be, the next level down would be a board and care. You don't have to go from one to the next, but you cannot go from an unlocked facility to an IMD, which is a locked facility. You have to go from a lock to a lock. So hospital or jail are locked. That's how you would get into an IMD. The next one is a board and care, and board and cares are not the best. Tour them. Make sure they're not a pimp house or a drug house or whatever, that they're doing what they're supposed to be doing. Sober living is a good place, or outpatient treatment. And they can even be in their own apartment under the LPS as they get on the road to recovery. Next slide. Suggestions for recovery. Once you get that LPS, remember what your loved one was like before their illness, and you're going to seek that level of recovery. If a doctor tells you this is the best you're going to get another doctor. Medications, be familiar with all their meds. Look them up on the internet. Call the pharmaceutical company that produces that meds if you have questions, but know what meds they're on. When people call me and they don't know what meds they are and they're conservators, I feel like, well, why are you even a conservator? You need to know what they are on. You wouldn't let your 5-year-old take a medication without knowing what they're on. It's the same thing. Get them in cognitive therapy. That's like, if you went to the gym and you rebuilt your muscles because they had all atrophied, it's the same thing. You're rebuilding your brain to make it work. If they have a substance abuse, now you can talk about substance abuse and get them into addiction treatment. But you want them on the road to recovery. And watch those medications. And I'm going to step out of the element right now and tell you, if they're putting them on Depakote, you have a person with serious mental illness, Depakote, Ativan, Seroquel, Zyprexa, those are not going to do squat for your loved one. You want to up the ante, and the class tomorrow will go further into that because we're running out of time. Next slide. Take the free family to family class. I think it might be 8. Some people offer 8 weeks as opposed to 12, and they have Zoom classes. Most empowering thing you will do to understand mental illness. NAMI Urban offers those classes, and they're excellent. They really are. Join NAMI. NAMI is one of the one group that you're going to hate to have had to join, but so glad you did. Get involved. Be part of advocating, helping to make things change. Next slide. Jim?
I'm sorry. I'm just looking at the time and I'm starting to sweat bullets here. You want to keep 2 journals. A journal for everyone to whom you speak. You want to make sure you get their name, date, and time, contact number, and what was said. You also want a journal for your loved one, what they say, what medications they're taking, with dosages and behaviors. These are really, really important. And I have to say that recently, I guess I was a little complacent in that, and I regretted it. It's very important that you actually do this, discipline yourself. Sometimes it's a little hard to do this, but please get involved with this, and we'll talk more on this later. But do that. Next slide. As the previous slide said, give yourself a break. Try to keep your sense of humor. Realize that you're your brother's keeper. You definitely want to look at the fact that these classes are very, very helpful to the community. And for those of you that are in a position to financially support the continuation of these classes, we would greatly appreciate if you could donate to NAMI Urban Los Angeles. This is their address. You can send them a check. But listen, hey, if you're on Social Security or something yourself and you're trying to make ends meet, we don't want you to donate. We wouldn't even think of you wanting to donate, and please don't. But for those of you that are in a position to keep these classes going, we would really appreciate your financial support in that sense. And then also, if you write a check in like that, please state on the letter that this is for the LPS Conservatorship Program. We want to designate your donation for the LPS Conservatorship Program. There's extra expenses involved in this. Next slide.
Well, let me just say, we would really appreciate some donations because right now, I didn't realize our funds were running so low. We don't need a lot of money, but we do need some. And our funds are running low because we're trying to expand this for the Spanish community and other communities. So if anything you could donate, we are greatly appreciative. Okay?
Let me say one thing before we jump off. And I'm just going to say, somebody asked me about, do I work for Be Well? No, I do not represent Be Well. Am I involved in drug treatment programs, multiple programs here in Orange County? Yes, please call me if you're dealing with substance abuse, and that's all I have to say. Please, Louis, it's yours. Thank you.
Take it away, Louis.
Thank you, Jim. Thank you, Gail. Good afternoon, everybody. I just want to take a minute to thank NAMI for having us come speak to your group today. My name is Luis Leiva. I am the Acting Deputy Director for the Office of the Public Guardian here in LA County. And it's a pleasure to be here with you all today. I'm going to be speaking specifically about the way the LPS program is ran here in LA County. We'll touch on a couple other issues related to the expansion of grave disability. We'll also touch a little bit about Care Court, and Miss Linda Boyd is going to jump in and help me once we get to those slides, okay? So we'll go ahead and jump right into it. Next slide. Okay, today's training objectives is to provide you an overview of the Office of the Public Guardian, an overview of conservatorship, the intent, the purpose and the types of conservatorships. Again, our focus today will be on the mental health conservatorship, also known as LPS. Okay. Conservatorship services available. We'll touch on those. We'll talk about inpatient and outpatient referrals. And we'll also discuss processes related to public guardian as the conservator. We'll talk about forensic cases. When I talk about forensic cases, that mainly has to do with the justice involved cases. Okay, individuals who have been declared incompetent to stand trial, but have pending criminal charges, either misdemeanor or felony. Okay, and again we'll touch a little bit on the newly established CARE Act here in LA County. Next slide. Just want to reiterate that all the processes that I'll be talking to you about today apply to the way LPS is implemented in Los Angeles County. Although the LPS laws apply to all counties within California, it is applied differently from county to county. And again, the processes that I'm going to be speaking on today are related to Los Angeles County alone. Okay. Okay, the Office of the Public Guardian is the designated county conservatorship investigator for all LPS conservatorships. All referrals for LPS are submitted to Public Guardian, and only the Public Guardian can submit the initial petition for conservatorship to the mental health court. Okay. Referrals can be accepted or rejected by the Public Guardian, and many of the reasons, a lot of times, the reasons why we don't make it a habit to reject referrals. Okay, we work very closely with the social workers, with all the referring parties, to make the necessary corrections or take the corrective actions to so that we can submit something to the court that we know will not be rejected on a legal technicality. Okay, so some of the main reasons why we would reject a referral from the onset would be that the individual is not a county resident. Okay. Um, Unfortunately, because LA County is such a huge county, we have a pretty big system of care that houses facilities within LA County, and people are placed on holds from our neighboring counties. We look very carefully as to where the individual's 5150 hold originated. Okay, if the individual is a resident of Orange County, Riverside, San Bernardino, even San Diego County, we would ask the referring entity to refer to the county of residence. Okay. We would also reject the referral if it lacks evidence of grave disability. Okay. We know our clinicians and our doctors are from many of the facilities that we deal with are stretched thin. You know, there's staffing shortages everywhere. However, if we're going to present a referral to place somebody on a temporary conservatorship, we have an obligation to make sure that it presents the necessary evidence where the court's going to establish the temporary conservatorship. Okay. That evidence is driven by grave disability. Okay. So that clinician has a responsibility to document and provide the necessary evidence that establishes why that individual is currently gravely disabled. Okay. Gail and Jim touched on that extensively when they went through their presentation. Again, the basis for grave disability is somebody who is unable to provide for their food, clothing, or shelter due to their mental illness. There may be many reasons why somebody is unable to provide food, clothing, and shelter for themselves. How it could be socioeconomic, or it could be something else. However, the purpose to establish a temporary conservatorship under LPS law has to tie that person's inability to their mental health condition. Okay. Many times we see incomplete referrals. The referral requires two doctors to sign the declaration of grave disability. A lot of times, unfortunately, we see hospitals who, again, are very stretched thin and are short staffed for some reason or another, leave key information out of the referral or key signatures. Okay. Again, we do go back and forth with these referrals and with these facilities and make every effort to submit a corrective referral to the court. Okay. Um, and just over the past 3 to 4 years, we have seen a very large increase in the justice involved cases for defendants who are found to be incompetent to stand trial. Unfortunately, that's becoming more and more our main referral source. Cases coming from the competency courts, the criminal courts, and even the jails, again, has overtaken the amount of referrals that we now see coming from regular designated hospitals. Okay, next slide. Okay, so what is a conservatorship? The conservatorship is a court proceeding to appoint a legally responsible person for somebody who is unable to provide for his or her personal needs or properly manage his or her finances. These are the three types of conservatorships that are currently handled here in LA County. The first, again, is the LPS, that's known as the mental health conservatorship. The second being the probate conservatorship, which Gail touched on briefly previously, and that is generally for your older adults with major neurocognitive disorders or developmental disabilities. Okay, our main source of the main referrals that we're getting, we see a large number of referrals sent to our office for both these type of conservatorships. The main difference again is the LPS is strictly to provide authority to approve treatment over somebody who's diagnosed with a DSM related mental health condition. Okay, for probate, those are generally individuals who are dealing with dementia or other neurocognitive disorders. LPS conservatorships need to be renewed every year after the date of establishment, as opposed to probate conservatorship, which generally lasts for the remainder of that individual's life. Okay. Legally, there's another housing conservatorship that the law allows for, but that's not currently available in LA County. The housing conservatorship, it is my understanding that San Francisco is the only county that's implementing that type of conservatorship currently. Next slide. So conservatorship, an LPS conservatorship proceeding is a civil proceeding requiring proof of need and attendance by involved persons. Okay, so proof of need really relates to its evidence driven by the circumstances that are provided by both the clinician that's referring the individual for conservatorship and the public investigator who's required to provide a thorough report to the judge to help them make a determination on whether or not the conservatorship meets the legal requirements. Okay, next slide. Okay, so the LPS Act, which was established in the 1960s, its intent and purpose was to end the inappropriate and indefinite and involuntary commitment of individuals. Okay, to provide prompt evaluation and treatment, to provide for individualized treatment, supervision, and placement, and to safeguard individuals' rights through judicial review. It also provides services in the least, it requires services in the least restrictive setting, and it also establishes procedures for involuntary treatment. Okay. Prior to the LPS, the enactment of the LPS Act, unfortunately, people that were dealing with significant mental health conditions really had no due process rights. The LPS Act established those rights and provided clear guidelines to the courts and to treatment facilities as to how individuals should receive treatment involuntarily. Okay. The LPS Act was a byproduct of the civil rights movement, and it making involuntary treatment more strict and provided for strict court oversight and granted patients due process rights. Again, for an LPS conservatorship, we are required to file for reappointment a year after it is established. And every time it comes up for reappointment, the conservator is responsible for providing the evidence necessary to establish that the person remains gravely disabled and continues to meet the requirements under the code to be conserved. Okay. Next slide. What are the effects of a conservatorship? The conservatorship, the end goal is to shift the responsibility for making personal care and financial decisions from the client to the conservator. As Gail mentioned, under an LPS conservatorship, you are provided either powers over person or also powers over person and estate. Okay. Um, Once you are established as conservatorship as the conservator under the conservatorship, you will be granted letters of conservatorship, and those letters or those court documents are the key to allow you to make decisions either for their mental health treatment and also to apply for benefits or to liquidate assets or sell assets, whatever is needed. Okay. Other effects of the conservatorship, it imposes upon the client significant limitations on his or her civil rights, such as where to live, the mental health treatment they can accept or refuse, whether or not they're able to execute contracts, manage their own personal finances, and in some cases, physical health decisions as well. Okay. However, despite these restrictions, conservatorship may provide the best guarantee of protection for the client's best interests. Okay. So as you can see, the invasiveness of an LPS conservatorship is rather high. Okay, it essentially removes somebody's civil liberties, and that's not something that the court takes lightly, and that's why this legal process, is so strict. Okay, next slide. One more, Araceli, please. Okay, what is the LPS inpatient conservatorship process? Okay, so the process starts with a client being placed into a designated facility, an acute psychiatric facility on a 5150, which is essentially your 72-hour hold for evaluation. Okay. If needed or required, the person can be held for an additional 14 days, which is known as the Welfare and Institutions Code 5250. At that time, the treatment team at the facility is making key determinations to decide whether or not this patient requires a referral for a possible conservatorship. Okay. Um, as Gail mentioned, this 14-day period is critical when families are communicating with the treatment teams. Okay. Providing the history of the individual is something that's key. It may be possible that the treatment team has no prior engagement with the patient. That's why providing the history of the client is critical for them to make a determination. Okay. Again, although grave disability from a legal basis is required to be proven currently, um, basically when we go into court, we need to show that the person's gravely disabled now, like today, right? However, all history related to that patient's um, episodes, the number of episodes, the number of inpatient hospitalizations is key for the clinicians to make a determination on whether or not it's time that this person be referred for and considered for conservatorship. Okay. After usually most of our referrals come to us within that 14-day period. However, there are instances where we receive referrals during the 30-day hold as well. Okay. Not all counties authorize the use of a 30-day hold. And if no intensive hold, then a temporary conservatorship must be in place by the end of the 14-day hold. Okay. Once we receive a referral from a designated facility, we will file the petition with the court. The patient is served a 5-day notice of action, informing the patient that a conservatorship action has been taken against them. That allows that individual to exercise any due process rights allowed under the law. Okay. we'll establish the what we also known as a TCON or temporary conservatorship, and the court will at that time set a hearing for the permanent conservatorship hearing. At the permanent conservatorship hearing, that is when the patient needs to be present in court. Okay. Referrals for LPS conservatorship usually sent at the end of the 14-day hold or beginning of the 30-day hold. And again, there's deadlines for submission of referral to meet notice requirements and also to allow for the extensive investigation to take place. Okay, so it's unreasonable for the public guardian to be expected to accept a referral 20 days into the 30-day hold. That does not allow us, the court, or county council to do everything that needs to happen in order to have a successful outcome at the time of the initial hearing. Um, Again, the public guardian investigator assigned to the case will interview the patient, will interview the doctor, and interview family. And at that time, if there's a documented history, we will ask the families to provide that documented history to the public guardian investigator as well, so that they can include key portions of that history into their report to the court. Okay. Next slide. Okay, for persons with LPS inpatient conservatorships are for persons with serious mental illnesses who require involuntary treatment. Only designated doctors and facilities can initiate LPS referrals. Currently in LA County, there are 40 plus designated facilities, including the jails. Okay. The designation requirement is in place to assure that the doctors providing the necessary medical testimony if the patient is contesting the conservatorship. As Jim mentioned previously, at the time of the initial hearing, the the patient has the right to contest their conservatorship. If they're contesting the conservatorship, they have the right to a jury trial or to a bench trial. Okay. It is key for us as the movers of the petition and key for our attorneys to make sure that the doctors that referred these individuals for conservatorship are willing and capable of testifying at the time of the hearing. That's why the designation process involves training to these clinicians to be able to testify at the time of the legal hearings. Okay. Next slide. Okay, LPS inpatient conservatorships, due process during involuntary holds. There's a, as we mentioned earlier, the patient can exercise their due process rights at any time. Okay, so during the 14-day period or the 30-day period during those official holds, there is the patient has the ability to fight the hold. Okay, those, and they do that through a certification hearing. These certification hearings are facility based. The legal basis is based on probable cause that the patient remains a danger to others, a danger to self, or gravely disabled. So at the time of the certification hearings, that does not involve the public guardian. That's a hearing between the facility who exercised the legal hold and the patient. Okay. At those hearings, the patient is represented by a patient's rights representative, and the hospital is represented by their clinical team. Okay. There's also Reese hearings. Just because somebody's on a involuntary hold does not mean that the facility can involuntary medicate them. Okay. If the person's not complying with medication at the time of the hold, the facility will ask for what's known as a Reese hearing. Okay. And those are mainly to involuntarily medicate the individual while they're on the hold. Okay. The legal basis for that is clear and convincing evidence that the person requires the medication for further stabilization. Okay. Next slide. What is the legal basis for conservatorship? Again, it is defined as somebody who is gravely disabled under Welfare and Institutions Code 5008. It is defined as the inability to provide for their own food, clothing, or shelter due to the mental disorder or impairment by chronic alcoholism. Okay. Um, the 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 as Jim mentioned earlier, it doesn't have to be all three. Okay. If a person's able to articulate a plan to be able to provide for their food and shelter, but is unable to provide a plan to provide for their clothing, then that person remains gravely disabled. Okay. Likewise, if a person can articulate a plan where they're going to get um, food and clothing, but is paranoid about being in a shelter, then that person is remains gravely disabled. And when I say paranoid, that mainly has to do with their mental health delusions. Okay, so even though again, we may interview a patient and they can say, I'm going to get my food clear and I'm going to get my my um, my clothing from this place, but they remain delusional about accepting shelter. Again, we will push forward and prove grave disability on the fact that they're not able to provide shelter for themselves. Okay. Somebody who suffers from alcoholism is rarely pursued under conservatorship as the primary diagnosis due to the lack of involuntary treatment facilities to treat uh, alcohol related conditions. Okay. All right. Next slide. Before I move on, I just want to touch a little bit on the recent expansion of grave disability. That was done under SB 43, which passed last year and came into effect in January of this year. So the new definition of grave disability now also allows for people to be placed on a hold due to substance use disorders and for untreated medical conditions that put them at risk of harm. Okay, so this is a huge shift and it's a pretty big expansion as to the previous definition that was provided by the law. Currently in LA County, again, Gail mentioned earlier, it is the implementation has been delayed until 2026 in an effort to expand the network of care and for the county to be prepared to serve the patients that are not going to meet criteria under the new definition of grave disability. Okay. Moving on to this current slide, the uh, the public guardian is appointed temporary conservator of the person only up to 30 days. Okay. So meaning if we establish a temporary conservatorship and the person's 15 days into their 30-day hold, we don't buy an additional 30 days after the expiration of the 30-day hold. We need to have that person have their initial hearing within 47 days of them being in the hospital initially. Okay. The temporary conservatorship does not extend that 47-day hold period. So again, there's very strict deadlines in order for us to do what we need to do in order to have a successful outcome. Okay. And again, the initial hearing is required to take place prior to the expiration of the TCON or the end of the 30-day hold period. While somebody's on a temporary conservatorship, the assigned public guardian investigator is responsible for reviewing the medical records, conducting a LexisNexis search to try to gather some information related to the background of that individual. They are responsible for consulting with the treatment team. They will make every effort to interview family if family is known. They will also interview friends or significant others. Okay. They are required to conduct a face-to-face interview with the proposed conservatee. Okay, that can be on the street, It could be at a hospital or it could be at the jail. In order for us to be able to paint a clear picture to the court as to the conditions by which this person was interviewed, right? If they're lacking insight, if they continue to have both visual and auditory hallucinations, those are all key factors for us to help prove our case in court. All right. And at the end, we're required to submit a comprehensive court report with recommendations to the judge. Okay. Next slide. Okay. We now have the ability to conserve somebody who is currently homeless, and that's being handled through our homeless engagement team or our home team. That was something that was piloted a couple years ago. It has proven to be very successful in helping us get people off the street. There is the home team is responsible for conducting intensive outreach and engagement to the chronically homeless population. Their whole goal is to get somebody to accept services voluntarily. However, if somebody is resistant to accepting services, the home team will refer for conservatorship. Okay. Street clinicians engage the chronically homeless clients for an extended period of time in order to obtain compliance with medication and possibly convince the client to accept housing. Okay, this engagement period also allows for the clinician to build the necessary evidence to support a conservatorship case. Okay. The goal of the home team is not to hospitalize somebody unless it's required for stabilization, but they will 5150 individuals if they're a significant harm to themselves or a danger to others, and has consistently refused services. Okay, next slide. Okay, so under WIC code 5008, again, it establishes that a person's inability to provide for their own food, clothing, and shelter. WIC code 5352 requires that a professional person may recommend conservatorship without the person being in an inpatient facility if both of the following are true. The professional person has examined and evaluated the person to determine he or she is gravely disabled. Okay, but again, our home team establishes that engagement period by routinely going out and engaging with that person, sometimes on a daily basis, requesting and offering services or providing medication or treatment out on the street. Okay. If the person's refusing, again, then they may need to exercise their authority to 5150 that individual to the hospital. Okay. The professional person has determined that a future examination on an inpatient basis is not necessary for a determination that the person is gravely disabled. All right. Luckily, the home team has had a lot of success in getting people to agree to services. So however, we are seeing a steady flow of referrals from the home teams for people that remain out on the street. Okay. The home team's priority is to engage and gain compliance with treatment and housing. And again, they will 5150 if the client circumstances presents an immediate danger to that individual or to others. All right. Next slide. Once we receive a referral from the home team, we will use the TCOM powers to initiate placement in the least restrictive setting to meet the needs of that patient. The least restrictive requirement is something that's mandated by the code. Okay, so If a person does not need to be 5150, then because clinically they're not appropriate or they don't meet the criteria for hospitalization, then the home team will find another potential open setting, either a skilled nursing facility or a boarding care, to place that person in, again, in the least restrictive setting to meet the client's needs. Okay. The home team's goal is to have limited use of the hospitals for acute stabilization, and will only use the hospitals if necessary for acute stabilization, to obtain medical clearances to move them to a lower level of care, or to obtain detox services. Okay. If a home team referral is accepted and we file with the court, we rely heavily on the testimony of the outpatient or the home team psychiatrist to help us successfully establish the conservatorship by the court. Next slide. Once the permanent conservatorship is established, the public guardian will work with the intensive care division within the Department of Mental Health to arrange for placement. That can either be what's known as an enriched residential setting that provides wraparound services, or it may be a IMD facility to provide involuntary treatment. The public guardian will also establish benefits, will apply for Social Security or all public benefit entitlements that the person is eligible for. If a person has a VA pension, we will become their payee and manage that pension for the benefit of the client. The case will be transferred from our investigation unit to an ongoing case management deputy, and they will work with the home team to provide services to the patient. Okay, the public guardian will be responsible for signing admissions agreements, signing medication authorities or approvals as recommended by the treating clinician, and we will also again work on establishing and gathering all benefits and managing whatever assets that person had, that whatever assets they currently have. So any bank accounts, retirement accounts, investment accounts, we are required to monitor those as well. Okay. If the conservatorship is denied by the court, the home team will continue to provide outreach and engagement to that person, and may re-refer once the circumstances meet the legal requirements. Okay. Next slide. So conservatorship should always be the last resort. Okay, that is something that is established by the Welfare and Institutions Code. The goal of the mental health of mental health treatment should not be that the first resort is to immediately conserve somebody. The court wants to see that all alternatives had been considered, and that conservatorship again is the last resort. Because a conservatorship removes many of the rights that we take for granted: where we live, what mental or physical health care to receive or accept, ability to handle our own finances. Again, it's very restrictive and invasive, and that's again why the court wants to see that this is the last resort option. Before a conservatorship is established, all viable and suitable alternatives to conservatorship must be investigated or tried before public guardian can petition or recommend all viable alternatives should be tried before public guardian can petition or recommend being conservator. Okay. And again, this is required by the Welfare and Institutions Code. Next slide. What are viable alternatives to LPS conservatorship? Okay. Ultimately, that somebody may be determined not to be gravely disabled. It is not too often, but on occasion we see that sometimes in the middle of a referral investigation, we'll get a call from the doctor saying that they want to withdraw the referral because the person has gained enough insight and has accepted treatment voluntarily. Okay. Unfortunately, our case depends heavily on the testimony of the doctor. And if the doctor is now saying that they no longer meet criteria under grave disability, we will ask counsel to pull that petition because we no longer have the evidence necessary to drive that petition through. Okay. The person is accepting third-party assistance. An individual or an entity has been identified that will provide that individual with food, clothing, and shelter. And again, the person will accept that assistance. Again, we as the conservatorship investigator have a responsibility to vet all third-party assistance plans, right? If we know that it's a person that has victimized the patient, or there's been a history of violence, or we feel that this is driven by undue influence, we will not make that recommendation to the court, and we will continue to work towards conserving that individual. We want to make sure that the third-party assistance component is in the best interest of the client. And again, we will not make a recommendation to the court unless we know that is the case. Okay. One other alternative to conservatorship is, again, that the person is voluntarily accepting treatment. Okay. We will pull a petition for conservatorship if the plan is for family to come pick up the individual and move them to a different state. The conservatorship powers granted by our court are only good in the state of California. So if the plan is for the person to, again, move out of the state, then basically the powers granted by the court, any powers granted by the court would be useless. If the person goes AWOL, okay. Unfortunately, because we're required to provide treatment in the least restrictive setting, on occasion we do have cases where people may go AWOL from an open setting. We will file a missing persons report. We will work with family to try to get the person to the location of the person, make us aware of where they're at. However, if we don't find them within 60 days, we may be forced to ask the court to terminate the conservatorship. Okay. Next slide. As mentioned previously, psychiatric testimony is needed to establish grave disability. On very few occasions now, we have people that submit at the time of the initial hearing to the conservatorship. I would say about 75% of the cases we file end up in a contested hearing. Again, that's either through a court trial, a bench trial, or a jury trial. The burden for establishing a conservatorship is beyond a reasonable doubt. This is the same burden of proof that is required in a criminal court. Okay, and that's why the evidence of current grave disability is necessary. This is all evidence driven, and the basis is current grave disability. The burden of proof is high due to the potential need to involuntarily treat or involuntarily medicate somebody against their will. That is why, again, the law sets the burden so high for us. Next slide. What happens once the public guardian is appointed and we move this case over to our case management unit? Once appointed by the Los Angeles Superior Court as the conservator over a person or the estate, the Office of the Public Guardian will manage the daily life and financial affairs of the conservatee due to their limitations. Next slide. Again, once you become conservator, or once the public guardian becomes conservator, there are a set of powers and authorities that are granted to the conservator by the court. Placement in an appropriate level of care that meets the client's needs and addresses condition and addresses condition that has caused that person to be gravely disabled. Okay. Again, we are required to place the person in the least restrictive setting to meet their needs. Okay. That may be 24/7 supervision, administration of medication, and providing food, clothing, and shelter to that individual. The power court also grants powers 4, 5, 6, and 7. The authorization of mental health treatment, including psychiatric medications, power 8 and 8A. It also grants limited medical consent authority to treat chronic medical conditions. Okay. However, if a person under LPS conservatorship needs an invasive medical treatment, we may need to go back to the court to ask for authorization to provide that invasive treatment. Okay. So again, just because we're appointed LPS conservatorship, the LPS only grants us authority to treat the mental health condition, not the physical condition. Okay. Even for a tooth extraction, we would be required to go back to the court and ask the court for authority to consent to that treatment. Okay. Anything that pierces the skin, any surgery, any biopsy, anything like that does require authorization by the court. Okay. The powers granted by the court that give us authority to manage the person's estate are covered under powers 11 and 13. It allows for contracting for placement, applying for all financial entitlements and benefits, and paying for the patient's bills, and to provide for personal needs funds. Okay. And it also grants us authority to walk into a bank and marshal bank accounts if necessary. Okay. Next slide.
Lewis,
Yes.
we kind of have to speed this up a little bit.
Okay. Conservatorship duration, LPS conservatorship lasts for 1 year, but they may be renewed. Okay. Again, there is the termination by law date is exactly 1 year after the establishment of the conservatorship. That is why it is essential to start gathering the documentations to get reappointed maybe a month or two prior to the end of the conservatorship. Okay, and submitting the filing to the court. If the doctor recommends for the continuation of the conservatorship, county council will petition for reappointment on the cases where the public guardian is the appointed conservator. For private conservatorships, the private conservator is responsible for filing the paperwork themselves. Okay, next slide. Conservatorship termination. The public guardian will request to terminate the conservatorship if and when the client is found by the treating psychiatrist or the public guardian case manager to no longer be gravely disabled. If the client goes AWOL, again, we will ask for termination if the client's whereabouts remain unknown for 60 days. Okay. Private conservators, if a reappointment is not filed, the conservatorship will terminate by order of law. Upon conservatorship termination, the public guardian, private conservator, no longer has the legal authority to act on behalf of the former conservatee, and it is highly likely that the facility where, if the client was in an involuntary or locked placement, that facility cannot treat that person involuntarily if the conservatorship terminates by operation of law. Okay. I know we're running out of time. I'm just going to talk really quickly about our forensic cases, and then maybe we can move on to AOT real quick. Okay. So again, forensic cases are the cases that are justice involved where the individual has been determined or declared incompetent to stand trial. We do receive referrals from the court or the jails. There are statutory requirements when the public guardian is to become involved. Okay. A lot of time, in many of our cases, the person has already been declared unrestorable to competency, to trial competency by the competency court, and the competency court will order the public guardian to investigate for suitability of LPS conservatorship in those matters. Again, for misdemeanors cases, those are usually cases where the charges are easily routed through a diversion program. Felony cases become a little more complex depending on the nature of the crime or the charges, the seriousness of the charges. Okay, so diversion programs may include Office of Diversion and Reentry, or assisted outpatient treatment, which Linda's going to talk about next. Or there's also rapid diversion, where a person's diverted into a mental health treatment program at the time they are indicted by the criminal court. There's also court linkages and liaisons in the criminal courts throughout the county that will help divert mentally ill individuals into the various diversion programs. Okay, and I know there's several more slides, but I think we touched on the most important parts of how the public guardian handles our LPS investigations and how we successfully establish conservatorships in the court. Okay.
Thank you, Louis.
You're welcome, Gail.
So
Linda?
if we could keep the go back to the care court slides, and I can talk a little about SB 317 as well. And I know we're going to need to rush through. But Luis, let me ask you a question. And I know that currently the third-party assistance can prohibit someone from being conserved because they're accepting the families, generally the families' assistance with food, clothing, or shelter. I know with the expansion of SB 43, I know the expansion of the criteria has been expanded. Does that third-party assistance still remain in place, that if the client's willing to accept food, clothing, and usually it's all three, and shelter from families, does that still prohibit them with SB 43 from being conserved?
Yeah, SB 43 did not change that criteria, Linda. So that's still in place.
Thank you, because I think that's really important for families for all of you to know.
One last thing before we move on,
Yes,
Linda.
go ahead.
I want to touch on the recommendation of the public guardian investigator. We will recommend family to act as conservator only if and when family is appropriate. Again, if there is a history of violence within the home, or the family has not acted in the best interest of their loved one, we will not recommend family to act as conservator for a client. Okay, we need to make sure that it's in the best interest of the client and that the family is willing and able to act as conservator and are appropriate. Okay.
Can I just add something on that? If at court, the patient tells or the client tells the judge he doesn't want the family member as the conservator, although they've been approved, the judge pretty much listens to what the patient or the client wants and then gives it to the public guardian.
That is correct, Gail. The court the court's main interest is to put the patient in the path of recovery, right? And usually a lot of times we find that we're appointed initially, the public guardian is appointed initially, but that doesn't mean that we can't consider family to act as successor conservator maybe 3 or 4 or 6 months down the line, once the person's stable and they're willing to accept a family member to act in that capacity.
Right.
Okay.
And another thing I think that Luis mentioned, but I think it needs to be stressed, is that LPS is for 1 year and must be renewed. It's not an automatic renewal. If you do not actively renew it, it will expire. And a lot of families don't realize that or understand that. Probate's lifetime is my understanding, but LPS is year by year and must be renewed, an active renewal.
And Gail brought up a very good point. If the family is going to act in the role as conservator, they should be asking the court to have a panel attorney assigned to them, so that panel attorney can guide them through the reappointment process as well.
Mhm.
Mhm.
Thank you so much. And good afternoon. It's a pleasure to be with all of you. I'm going to go through Care Court real quickly, and maybe at some point now that Care Court has been has gone live in LA County, maybe at a later date we can go through all of the Care Court criteria. But and it's interesting because I was in court yesterday because AOT court in LA is on Fridays. We also have Judge Herron for AOT. So Judge Herron is doing AOT, LPS, and care. Also a new judge, Judge Renee Gilbertson, R-E-N-E Gilbertson. It's a female. Came on board December 1st, and she also right now is doing LPS, Care Court, and AOT. So now there are 2 judges doing LPS. And so I was in court with Judge Herron yesterday, and we always talk about care being AOT 2.0, and he said, no, I don't agree with that, because he said 2.0 implies it's better. And he said he calls it AOT light. And I think that is a much better description. So you all know that Governor Newsom rolled out Care Court and touted it as a way to get the homeless folks off of the street. And interestingly enough, Department of Mental Health has gotten about over 60 referrals from families. It started December 1st in LA County. We've gotten over 60 referrals from families. And about 50% are housed and about 50% are unhoused. So you do not have to be homeless to be a part of care. It stands for Community Assistance, Recovery, and Empowerment. Next slide, please. So this is the criteria, and I'll go through it quickly because you'll notice that the requirements for care, and when I go to AOT, the requirements for AOT and care are very, very similar. A person must be 18 years or older. For care, the diagnosis criteria is very, very narrow. They must have the schizophrenia spectrum or other psychotic disorder. So schizophrenia, schizoaffective, schizophreniform, schizotypal, personality disorder. If someone has bipolar disorder with psychotic features, it does not qualify. Depression with psychotic features does not qualify. So the diagnostic criteria is very, 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 very narrow. They're not clinically stabilized in their ongoing treatment. And then one of the following is true. They're not likely to survive safely in the community without supervision, and their condition is substantially deteriorating, or they are in need of services or supports to prevent relapse deterioration that would result in grave disability or serious harm to self or others. Participation in the care program or care plan or agreement would be the least restrictive option, and the person is likely to benefit. And I stress those because that is exactly the same criteria for AOT. So you could substitute care with AOT and vice versa. Those are exactly the same criteria. Next slide, please. So again, the person, it can be where the person resides, or where the county where the person resides, or the county where the person is found at the time of the application to care. So if they're in LA County at the time the petition is made, then LA County will proceed with that care petition. And also, or if they're in jail or facing criminal proceedings in LA County, even if they're an Orange County resident, we will follow through in LA County and notify Orange County. Who can refer? You'll notice these also are exactly the same with few exceptions to AOT. A person with whom the respondent resides, a spouse, parent, sibling, grandparent, or other individual who stands in place of the parent, the director of a hospital where the person is hospitalized, the director of a public or charitable organization, agency who's provided services, so a board and care, residential treatment program, where the person has been provided services, a licensed behavioral health professional who has seen that person within the past 30 days, a the first responder, peace officer, firefighter, paramedic, EMT, mobile crisis, homeless outreach workers. So paramedics are not included in the AOT criteria. They are included in the care criteria. The public guardian or the conservator of the respondent, the director of a behavioral health agency. APS also can refer to care but cannot refer to AOT. Any California tribal mental health department or the judge of a judicial tribal court in California. Also, the judges, the Superior Court judges in mental health court for SB 317 clients, for folks who have committed a misdemeanor who are deemed incompetent to stand trial, can refer to care. Any Superior Court judge in LA County can refer to AOT. Next slide. And so we'll go through, I think we can go on to AOT because most of these are exactly the same as AOT, so I'll explain it for both. Next slide, please. Next slide, please. Next slide, please. Because I think we could do a whole presentation on care court, and I'll be happy to do that next time, but I know we're running out of time and we want Dee Dee to have time to present. So care and AOT, the courts are right now in courtroom B of the Norwalk Courthouse. So conservatorships are being held in courtroom A. The care court hearings and the AOT hearings are held in courtroom B. Judge Heron and Judge Gilbertson switch back and forth. They alternate for AOT, they alternate Fridays, and I believe they alternate weekdays as well. So this Friday was Judge Heron's day in AOT court. Next Friday is Judge Gilbertson's day in AOT court. So they kind of go back and forth. And you'll notice Division A and B is on the second floor of the Norwalk Courthouse, and their courtrooms are right next to each other. So the two judges for right now are doing all three types of hearings. Next slide, please. And then maybe we can hold this till the end. Next slide, please. Can we go to the AOT? So while you're setting up AOT, I think most of you know that AOT, assisted outpatient treatment, also known as Laura's Law, was established in 2002 after Laura Wilcox is a college student who was volunteering at mental health clinics during her vacations from school. So during the winter, she was volunteering in a clinic in Nevada, California, in Nevada County, which is a small county in Northern California, when someone who was non-compliant with treatment came in and killed her, went to a restaurant and killed the manager of a restaurant and injured someone else. And I believe also injured someone in the mental health clinic. The family sued and wanted there to be treatment for folks who are generally non-compliant with treatment. In 2002, and that happened in 2001, in 2002, Helen Thompson put forth Assembly Bill 1421, and Jim mentioned that bill earlier, which contained a lot of things, one of which is 5150.05 of the Welfare Institution Code, which says that anyone evaluating someone to put them on an involuntary hold or a 5150 shall consider the history of the client, shall take the information from family members or someone else, if they believe the information is related to what they're doing, which is evaluating to see if they need involuntary hospitalization, and if they believe the person giving that information is credible. So, and it doesn't say may, it doesn't say could, doesn't say, well, if you feel like it, it says shall, which I think was geared more for law enforcement, but applies to all of us in mental health who are able to implement 5150s. We shall consider your information. So you can give history of what your loved one is doing that makes you believe that they meet the criteria for 5150. It also established the Laura's Law, or Assisted Outpatient Treatment Program, initially as a pilot program, and it was executed only in Nevada County. In 2014, Governor Brown at the time said that counties could use Mental Health Services Act money in order to fund AOT programs. And so then they began to populate throughout the state. Counties have the ability to sign in to AOT programs, or the ability to opt out of providing AOT in their county. Care court must be in every single county. All 58 counties in California must establish care courts, but counties had an option with AOT. So Orange, San Diego, Ventura all have AOT programs. I don't believe San Bernardino does, and I don't believe Riverside has an AOT program either. Next slide, please. So what it does, it allows the Department of Mental Health to really try and institute some treatment for folks before they meet the criteria for 5150. And also what we try to do is outreach to folks so that we can provide for them a full service partnership, or, as Luis mentioned before, enriched residential services beds, which are called ERS, which is a little higher level of care, although nothing we have in AOT is locked. Everything we have in AOT is unlocked. And for the enriched residential services beds, the client must agree to be on medication, and they must agree to be housed in an ERS facility. Those are all voluntary. Next slide, please. If the client refuses services, we can petition in mental health court for mandated treatment. And so if I jump around a little, forgive me, because I'm trying to speed things along, but there is no involuntary medication either with the AOT program or the care court program. So we cannot, if the judge may order medication, but if the client does not want to take medication, then there is no way for us to give that client any medication against their will. I think Powers 8 and 8A through conservatorship is one way. And if a client is deemed felony incompetent to stand trial is another way that they may be able to be given medication involuntarily. It was prior to the passage of SB 317, it was that misdemeanants who were deemed incompetent to stand trial could have gotten medication involuntarily, and they could be ordered to treatment involuntarily. With the law change, I want to say in January 2022, that changed, and even now for folks who have committed a misdemeanor and are deemed incompetent to stand trial, can no longer be given medication against their will, and they cannot be compelled to treatment either. So the other thing that happened with AOT is that it expands our interagency collaboration. So we're collaborating much more with courts, with county councils, with public defenders. We've always collaborated with patients' rights, and the Department of Mental Health has a co-response model, meaning it teams together a law enforcement officer with a mental health clinician in 39 of the 48 law enforcement jurisdictions within LA County. And their sole responsibility is to respond to 911 calls involving folks who are experiencing a psychiatric crisis or a critical incident. Next slide, please. This is the criteria for a person to be eligible for AOT, and you will notice a lot of these are the same as with care court. The person must be 18 years or older. One of the differences between AOT and care court is any treatable illness in the DSM qualifies for AOT. So bipolar disorder, PTSD, major depression, dementia, anything that is not treatable will not qualify. Substance abuse alone does not qualify either for care or for AOT. So there's a broader category of criteria of mental illness, serious mental illnesses that will qualify for AOT. The person must, again, be unlikely to survive safely in the community without supervision. And it's also to prevent relapse. And here's another little difference. So they must have a history of non-compliance with treatment. And so this is generally non-compliance with any treatment. So we get referrals and the person is seeing a case manager regularly, but doesn't want to take medication and doesn't want to see a therapist. So they are complying with some form of treatment. So they're, according to the statute, they don't meet AOT criteria. The care court criteria says they're not stabilized in treatment. So they may, if they have schizophrenia or schizophrenia spectrum disorder, may meet care court criteria. So two of the things that, so one of three things has to be there for AOT. They must have 2 or more hospitalizations in the past 36 months, or 2 or more forensic incarcerations in the past 36 months, which means they're getting mental health treatment in custody. So for the men, generally that's Twin Towers. And for the women in LA County, it's CRDF in Linwood. And they have some, they don't have like a Twin Tower as a separate section, but they do have sections where they're providing mental health treatment in custody. Or a threat or attempt to cause physical harm to themselves or others within the last 48 months. And the reason we say months instead of calendar years is that according to the statute, if someone had a hospitalization, let's say in January of 2021, it's now February of 2024, that January 2021 hospitalization has fallen off. It goes month by month. It's not calendar year. The person has behaviors that are likely to result in grave disability or serious harm to themselves or others without treatment. They fail to engage in available treatment, which means, again, the non-compliance with treatment. They must benefit from the AOT program, and it must be the least restrictive setting. So you'll see in every court-ordered treatment, LPS, AOT, care, it's always the client must be in the least restrictive program. And I think throughout California, all of our programs, the criteria are always in the least restrictive setting. And that the person will benefit from AOT. Also, that the person will benefit from care. Next slide, please. And I'll answer, I'm seeing some things pop up in the chat, and I'll be happy to stay afterwards and answer any and all questions that anybody has. With AOT, we provide outreach for a minimum of 30 days. We provide screening, we provide assessment. If the person is willing, we will connect them to a full AOT full service partnership or to an ERS setting. If they're not complying and they are deteriorating, we will petition the court for court-ordered treatment. And I can, next slide, we'll go into that a little more. So who can refer? And you'll notice that this is also pretty similar to the care court. So a roommate, somebody who's over the age of 18, a close relative, parent, sibling, spouse, an adult child of the person. And again, if there's an aunt who's been in the client's life and they're really acting as a parent, we also consider that as well. The director of a residential facility or a hospital director, licensed mental health provider, peace officer, parole officer, probation officer, and the judge of a superior court. Next slide, please. And so this is really the process. If you look in the upper right-hand corner, we receive the AOT referral, and you can Google AOT LA. It will pop up Assisted Outpatient Treatment Los Angeles. At the bottom of that, it says new referral form. That referral form addresses the 7 criteria for AOT, and we ask you to fill that out as completely as possible. And there is at the top of that referral form an email where you can email the referral form. So every Tuesday afternoon we meet and we go over the referrals to make sure they meet AOT criteria. If the person is involved in other services and is being seen, we will refer that person back to those other services. And as a part of the investigation that we do, we will call family members, we'll look in our electronic records, we'll look in our Department of Health Services electronic records, which includes records from jails, because the Department of Health Services provides mental health in jails. It also shows any services that have been provided in any of our 3 county hospitals. So we research all of that. If it's one of our mobile crisis teams or a law enforcement team that's referred the client and they list the family members, or we have your information in our electronic records, we will call you. We will ask for your history. Gail's history, and that Jim and Gail have talked about, is invaluable. Please just make sure that when you're looking through their template, that you only include the symptoms that are happening for your person, for your family member. Often we get those histories and everything is left exactly the same. So we can tell that the template's been submitted without making it specific to your loved one. And we really need it to be specific so that when we're addressing those symptoms with the client, with the court, with whoever, that we are really speaking specifically about your family member. And then so the cases are presented to the referral team, which I said occurs generally on Tuesday afternoons. If they're accepted, they've met the criteria, then the teams start to outreach, usually within that week or the week following. We have been short of staff. I think every mental health department, particularly servicing folks in the community, in the field, whether homeless or housed, are having difficulty recruiting since COVID and the advent of telehealth, where folks can stay home and earn more money by servicing clients via telehealth. So we are short-staffed right now. If the candidate's refusing and they are deteriorating, then we will petition them for mental health treatment. And so let me just say, because this sometimes gets to be difficult, and we know that you have family members who may sort of isolate all the time in their bedroom, but they're eating and they're sleeping and they're not making any threats. They're accepting all the food from you. They're not deteriorating, and this is sort of their baseline. They're refusing all of our services, but we don't have any real criteria to be able to bring them to court, because the public defender, and we'll go into that in a second, is going to fight like heck to have that person not be petitioned because they're not deteriorating. And so while we would all love and want very much for that person to get into treatment, to be able to begin their recovery process, if the client is accepting all of the food, clothing, and shelter, they're not threatening suicide, they're not threatening family members, they're just sort of isolating and existing. As much as we would want more for them, they're not going to qualify for us to be able to bring them to court. We also have clients who we accept into AOT who they live alone, they never, ever, 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 ever open the door. They may live in a security building, and we will wait for someone to come out so we can get into the gate or into the building, and we will knock on the door. As Gail said before, police will not assist there, and they cannot assist. It's not they won't, they cannot. There is no exigency. So they have to have exigency in order for them to break down a door. Sometimes family members will help and unlock the door. Sometimes family members don't have access. And sometimes, for a variety of very good reasons, family members don't feel like they can open or should open the door. So for those folks, we also have to at some point close that referral. And then most of the referrals get closed because the client is homeless and they move around so much that we really cannot locate them to continue any type of outreach. It also does happen that when we're reviewing it, we really know this client needs a higher level of care. And I advocate that we take those clients anyway, and that we sort of, try and prove that they need a higher level of care. If we hospitalize someone on a 5150, we advocate always to the hospitals to be able to conserve that person. And that, again, as everyone has already mentioned, is totally up to the doctor. And given the constraints of the number of beds, the times that folks, through no fault of anyone's, have to wait for placement because beds are limited, the hospitals are not anxious to conserve folks. And I think all of you on this call have had some experience with that, unfortunately. So we will advocate. We do go to court if our clients are involved with the criminal courts. We do go to court to advocate for mental health treatment. We visit clients in custody. We all have we try and get all of our staff to have jail clearance to be able to go into the cells, not just on video, but to go into the cells to see the clients face to face. Next slide, please. If a client's seriously deteriorating and we feel like that we need to petition the client, we have a psychologist, and she sort of went away and came back, so she's coming back next week. The person testifying in court must be a licensed mental health professional. With CARE, it can be an associate, a person who is gaining their hours to take their licensing exam who can testify, as well as a licensed mental health professional. For AOT, it must be a licensed mental health professional. We have a psychologist who, except for the last few months, has been doing all of our petitions. By statute, she goes out. So we have an outreach team who's outreaching to the clients a minimum of once a week. And that consists of licensed mental health therapists, marriage and family therapists, licensed psychiatric social workers, community mental health workers with lived experience, medical caseworkers, nurse, psychiatric technician. That's and we go out in pairs, and we do the outreach teams. That's the outreach teams for our AOT, outreach portion of AOT. And then when they feel like the client really needs to be petitioned, our psychologist goes out with them, and she tries to examine the person. So it's not a full psychiatric assessment. It's enough of an examination that she can see the symptoms of the mental illness. She talks to the client if the client's willing to speak to her. So she needs to be able to verify they have a serious mental illness, they have the symptoms of the mental illness and how it's interfering in their functioning. She researches all of the medical records and interviews the family and everyone else who's involved. And then she offers, by statute, by law, we must offer the client a treatment plan. She offers a treatment plan. The clients usually refuse to sign it. Within 10 days of her seeing the client and offering that treatment plan, she writes a declaration attesting to the facts that lead her to believe the client meets criteria for AOT, and that's under penalty of perjury. So, and that's submitted to our county council, who draws up a petition, sends it back to the Department of Mental Health. Right now, our medical director signs those petitions, sends them back to county council, who files them with the court, and within 5 days of the filing, a hearing is set. Next slide, please. So the AOT program has one dedicated public defender, Julianne Prescott, and the public defender's offices in LA County have licensed clinical social workers assigned to them. So the licensed clinical social worker for Julianne is John Valenzuela, and we have one dedicated county council person who represents DMH, and that is Craig Kirkwood. Our public defenders, so with Care Court, the difference is they have panel attorneys. It's not the public defender's office. It's the independent counsel panel attorneys who have agreed to be the defense counsel for the Care clients. Our AOT public defender, as well as the Care independent counsels, do go in the field and they do see the clients prior to the hearings. So our public defender, Julianne, with her social worker, John, will go out to see our clients. At that time, the petition has been filed, and she goes out and talks to the client, explains what's going to happen, and our teams have already done that as well, explained what's going to happen in court. At that time, our client may say, can't you take a joke? And they sign what we call a settlement agreement. So they're still under the court's purview, but there is no court hearing. So they sign a settlement agreement, which means they agree to comply with the court's rulings of therapy, case management, medication support, and then anything else they may need. Substance, then this is all in the treatment plan that we present to the court. So if the person needs substance abuse treatment, we include that in the treatment plan. We've had clients who've had eating disorders. We included residential eating disorders facility in the treatment plan. And so the client agrees to that treatment plan, and the public defender at the time of the petition hearing presents that to the judge. No hearing is held. The judge affirms with the client, they agree with the services to be provided, and the commitment time for AOT is for 6-month increments. They can be repetitioned at the end of 6 months if more care is needed. If the client says pound sand, and you all know that's sometimes the nicest thing the client says to us, a hearing takes place, and it is a regular hearing. So our psychologist is sworn in, our county counsel asks her the questions to attest to the 7 elements of the AOT program. Our public defender cross-examines her. The client, if they want to testify, may be sworn in, and our county counsel may cross-examine the witness, and then the judge rules. One thing I have to say, and I know Gail mentioned earlier that that on your sheet, you don't want to put if the client is violent. Since one of the criteria for AOT, we often have clients who've not been hospitalized. There's no requirement that someone needs to be incarcerated in order to qualify for AOT. So maybe the petition is on threats only. Our public defenders, so if we go to court and we say, mom has reported to us that the client has pushed her 3 times. In the court, that's hearsay. Anything that happens outside of court is considered hearsay, the Sanchez rule. So we can put that in the affidavit, but we cannot testify to that under oath. So unfortunately for AOT, if the petition is solely based on threats, the person who has been the victim or witnessed the threats must testify. We have had incidences where we go out and we're talking to the client and we say, I understand you pushed your mother, and the client says, yeah, I pushed her 5 times because she did XYZ. Then my staff can testify to that because the client told them that directly. That's not hearsay. Or I understand you've attempted suicide. The client can say, yes, I tried to cut myself, or I did whatever. Our staff can testify to that. That is not hearsay. If the client says, I never did that, my parents are lying, then we must have the person who's been the victim or who's witnessed it to testify. We understand that can create some issues. And so sometimes you're the only person who has a good relationship with your family member, and you don't want to disturb that. And we don't want to disturb that either. And sometimes if your loved one has been violent and you're concerned that if you testify, they're going to become more violent, we have had times where Craig Kirkwood, our county counsel, will interview you over the phone. He'll write that testimony up. He'll present it to our public defender. Our public defender may call you to feel like just to vet it. She usually doesn't. She'll read it if she believes that this is true and happened. We present that to the judge. The judge generally accepts that written testimony, and it's entered into the court record without anyone having to testify in court. Many of our family members say, you know what, I really want my family member to get the help that they need, and I'm willing to do whatever is needed to do that. So there may be times when witnesses also testify in the hearings. Then the judge rules on whether the petition is sustained and the person is mandated into AOT treatment, or whether we have not proved our burden, which for AOT and care court is clear and convincing evidence. So it's the standard is less than necessary for a conservatorship. And so, knock on wood, we've been in existence since 2015. We've had a variety of judges, and I believe maybe a handful. We've lost maybe a handful of petitions. Both Judge Heron and I agree with Gail, he's superb. And we've had a few hearings with Judge Gilbertson, and I find her also to be extremely compassionate. They're both extremely client-centered, and they both very much try and do whatever we can to get the client the services and the treatment that they need to be able to be on the road to recovery. With COVID, before COVID, people all came into court. Since COVID, people can appear on WebEx, and most of our clients do appear on WebEx. And in 2021, I believe it was put in as a permanent part of the statute that folks can appear on WebEx. The same is true for Care Court, but since we've just started having the hearings for Care Court, because we just started the process December 1st, they're asking for the judge's permission before folks come on to Care Court. So folks,
Linda,
and the way people
can-
are petitioned are a little different. Did you want to say something, Luis?
Yeah, for the purposes of an LPS conservatorship, the public defender is still, they're not waiving in-person appearances, and the court's expecting people to be there in person.
Right. Thank you.
Including the doctor?
The doctor
the-
can testify remote, but the
But
patient
the
needs to
client
be in
has to
court.
be there. Right,
Mhm.
okay.
That's correct.
Yeah, thank you for that, Luis. Yeah, I forgot to mention that. Thank you for that. Next slide, please. So the court orders the treatment for 6-month increments. And then what happens is that after the court orders the treatment, we have what's called progress reports. So if the client is doing well, they're seeing their therapist, they're meeting with the psychiatrist, hopefully they're taking medication, they're meeting with the case manager. And the case manager's job basically is to provide whatever services, establishing benefits, getting them Medi-Cal, if they want housing, looking for housing for clients. If they want to go back to school, if they're looking for employment, to be able to try and get the client whatever the client wants and needs. And so the judge will order those things. He really sometimes puts a lot of pressure on the full service partnerships, rightfully so. Again, there is no forced medication, and we really in AOT rely on the black robe effect. And that is absolutely critical. And there was something I was going to say when I was thinking about the oh, I know what I was going to say. So sorry, when you get old, things come in and out. Jim and I can identify with that. Sometimes family members who are a part of or here, because we go out in the field, we're often interviewing folks in their home. And sometimes family members are privy to that conversation. Although if the client doesn't want the family member to be a part of that conversation, we ask that you respect their privacy, because part of the whole thing is for us to be able to establish trust with the client and a relationship with the client. That's where things go best. But sometimes when families hear it and the client's talking about wanting a job, and the case managers talking to them about how they can get a job and stuff, and we all realize and recognize that the client is nowhere near ready to get a job. So family members are getting upset, saying, listen, you're talking to Johnny about getting a job, and Johnny's having trouble taking a shower every day. And I want you to understand, the full service partnerships know that. But if we say to the client, you're not ready to do any of that, so let's stop talking about that, then we're going to turn the client off. We're going to ruin any chance of a relationship. And and those of you who know that treating any mental illness really is based a lot on the relationship. So we really try and meet the client where they're at. And even if we know they're not ready for some things, we will discuss it with them, because we want them to feel some hope. We want them to feel that we're listening. We want to validate their concerns. And so I know how frustrating it can be. I know how frustrating it can be to hear them talking about things your family member's not ready for.
Yeah, Linda, we
uh-huh.
need to speed it up again.
Okay, that's fine. We're almost at the end. Next slide, please.
I figured.
Yeah. So we do assign the client to an FSP or to an ERS. So the AOT, we had tried to assign them to an AOT FSP. The legal statute says that with AOT FSP, it should be 10 clients to 1 per staff person. With regular FSPs, it's 15 or more per staff person. So it's 10 to 1 for AOT. The other two things that we have in AOT that they don't have in care is that we have, if a client, the psychologist goes out, the client will not talk to them. The client says, I don't want services, thank you very much. The psychologist cannot establish that the person has a mental illness because anybody can refuse, right? So we asked the court to issue a 5346D, which allows us to hospitalize a client for up to 3 days for the hospital to establish if they meet AOT criteria. The next is a 5346F, which is the client is in treatment and they're not complying and they're deteriorating, they're not doing well. We asked the court again to order a 5346F. The 5346F could be by statute or the provider can do that on their own. In LA County, for the reasons mentioned previously by other folks, in order to have law enforcement help us, a part of the order, the court order says law enforcement can use reasonably objective force to detain the person to be able to be hospitalized. Generally, those folks are also going on a 5150 because they do meet 5150 criteria and they meet medical necessity, but they don't have to actually meet medical necessity 5150 criteria to put them in the hospital under AOT. They can be what I call 5140, 5149, and 5149 and a half. But we do use this order to try to get officers to give them permission to use reasonably objective force, not tasing, not banging doors down, but officers often, with the advent of cell cameras, you know that they've been, as everyone has spoken about, less and less and less willing to help because it can be a use of force. But we want them to be able to, you know, take that person maybe by the elbow or assist that person with getting on the gurney. The court order allows that. And even with that, sometimes officers aren't willing to help. More than likely, they do help us with that court order. Next slide, please. Next slide, please. So this just is the benefits of AOT. People don't have to be, don't have to have a criminal history. We try and outreach to them. And I noticed someone in the chat mentioned earlier, it is, even though there is a court order, we don't have a stick, and there's less of a stick with care court. And we all know as of right now, it may change with SB 43, there is no involuntary drug treatment program in the state of California. The judge will order it if we have it in our treatment plan, understanding that there is no we cannot treat someone involuntarily. The same with medication. They may order medication knowing if the client doesn't want to take it, they won't. But sometimes when the judge orders it, the client says, oh, if the judge orders it, I have to do it, and they agree. So that's, next slide, please. The next slide, this just talks about where we fit in our spectrum. So thank you all very, very, very much.
Thank you, Linda. Appreciate it a lot. I always learn so much from you.
Thank you.
Okay, Dee Dee? She's still here?
I am.
Good. Thank you.
Hi, everyone.
I appreciate this a lot.
Nice to see you, Gail. Linda, you're a hard act to follow. But I'm gonna specifically talk about law enforcement teams. I'm actually, Linda hired me 18 years ago. I've been at Smart Team. Smart Team is the joint venture between Department of Mental Health, me, and Los Angeles Police Department, LAPD. We have law enforcement teams all over the cities, and it's the same concept, a clinician with a officer. Sometimes, not sometimes, a lot of the times I get families calling me wanting help from us because their loved one does not want to go to the hospital. They cannot make them go to the hospital. And if it's an LAPD jurisdiction, then I help them. If it's not, then what I do is I bring in some of the other law enforcement teams. Another thing that I do is over the years, my position kind of has morphed at SMART. I started as a line staff going out on calls myself. Then I became a supervisor. Then I went to our camp unit, which is the follow-up part of SMART, where we get high profile cases. And now I do a lot of work with our senior lead officers. And at SMART, we have 4 bureaus, and we have a senior lead officer in Central Bureau, in the Valley Bureau, West Bureau, and South Bureau. And I work with them in helping families get the help that they need. A lot of the times I'm advising families to call 911, and then I follow up. But then sometimes we can orchestrate a call without patrol and directly responding to wherever it is we need to respond. One thing I want to tell you that the senior lead officers are doing, the SLOs, and it's kind of more of a new thing. They are going to all the LAPD roll calls, and they are talking about the conservatorships, conserved patients, um, specifically how if someone is conserved and they see the paperwork, they're bringing the paperwork there, Gail, okay, and showing them the paperwork and saying, this is what we have. The officers are now recognizing that paperwork, and they still have to place the person on a hold. And it's only because the hospital requires it until they get the paperwork vetted out. But I've advised them, the senior lead officers have advised them, the patient is conserved because, conservatorship is prima facie GD, grave disability. And they're now wrapping their heads around that. And they're putting the patient is conserved, the name of the conservator on the hold. And, something like the patient is conserved and the last time they weren't taking their medications, this is what happened. So that's happening like right now. All our senior lead officers going to roll calls and training or teaching the patrol units that if they come across a conserved patient, that this is what's got to happen. And Gail and I have talked about it many times. So I thought what I'd do is talk about when you guys call 911 and what's the information that they're going to be looking for. So basically we're going to advise you, like I said, there's special circumstances where I'm going to gather my resources and go out myself with possibly the senior lead officers. But generally, if you call me, I'm either going to do that, handle it by knowing who's who in the zoo. Maybe the person is in Long Beach, and I'm going to call someone over in Long Beach that I know, a law enforcement team in Long Beach, and say, hey, this is what we have. We have a conserved patient, and mom is the conservator, and she's like saying that her loved one needs help. But if you call 911, so they're gonna ask for certain things. Just so you know, that if your family member's in crisis, they're gonna ask for certain information, like your name, your address, the nature of the crisis, what's going on. My loved one threatened to hurt themselves, or they're not taking care of themselves, they're not taking their medication, da 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 da. They're specifically, the police are going to ask 2 important questions. Is there a history of violence? Is there weapons in the house? Then they're going to ask you name of the person in crisis, height and weight, clothing, current location, their diagnosis. They're going to ask that. Any drug use? What are the triggers? Previous police contacts, important. Identity of other people in the residence, very important thing. So I'd like to talk about an LAPD policy, and it's been a long time policy of the sheriffs, but LAPD most recently adopted it. It's called, Gail and I have spoken about it, it's called disengagement. So the police have done a lot of research on calls that might involve a use of force, where somebody is going to get hurt, either them or your loved one. So if somebody is barricaded in their home, or they're just threatening to harm themselves, then they've determined that it's better to walk away from that situation than trigger, no pun intended, trigger a bad situation where the person does harm themselves or harms the police. So they will disengage. Those calls, we don't just let it go. So all those calls, that disengagement calls, we refer those to our camp unit, our case assessment management program. Okay. And it's detectives working with clinicians like myself. We're all in the same office, and they follow up. Like, maybe it's going to be a better time to go out there and address the crisis. So just want you to know that. The other thing I want to talk about is what happens when what happens, who responds to the call when you call 911. I'm sure a lot of you, all of you probably have called 911 in the past. And at SMART, we have a co-response model, and here's how it works. So if you call 911, they're going to ask for co-response SMART. And the smaller agencies, like the sheriffs, I guess it's the same, or the sheriffs is the same thing, but like the smaller agencies, like say Pasadena, Glendale, Burbank, they respond themselves. They're first responders. We co-respond with LAPD. We hear it on the radio, and it's asking for a co-response, and patrol usually gets there first, and they secure the situation. And usually your loved one is handcuffed. That's their policy. I know that's hard for families to feel good about, but when my son was going through his stuff, I'll tell you, I'm like, please handcuff that boy before he does something stupid. I mean, so yeah, so they're gonna handcuff. The officers will conduct a preliminary interview, and then SMART will be like in the background, and then they'll, over the radio, they'll say, yeah, please request a SMART response. They'll be in the area kind of holding back, because as clinicians, even though we have access to vests and all that, we're civilians, and that's just LAPD's policy. So the officers conduct a preliminary intervention or interview. They'll get all the information. They'll get, it's called a PR, the person reporting. So you're the person reporting, the family member or whoever, and they'll get that. And when the clinician and the SMART officer gets there, they're going to determine if the person meets criteria to be 5150, but also they're going to determine if they see that paperwork, they're going to determine that, you know, they don't necessarily have to meet criteria. If you, as the conservator, tell me the conservatee is not taking their meds and they're decompensating, whatever, you know, we're gonna scratch out that hold. But like I said, the hold is only until the hospital vets it out, and they are gonna like lay you out and say, so and so is the conservator and believes this person, their loved one should be hospitalized. So on my paper here, it says if the person is an adult, you know, we're bound by, you know, HIPAA, but I will try myself personally, and I know my colleagues will try to receive any information I can. You know, I might not be able to tell you where the person is, but are going, but I'll try and do everything I can because you know, I believe you know, the family is so important into the recovery or of their loved one.
Didi, if I can interrupt,
Of course.
when, what was it? One of the fellows who was head of DMH or whatever, I forgot what it was. When the police transport to the hospital, I was told they can tell where they're going because that's under civil. Once they cross the threshold of the hospital, now HIPAA takes place. And so pretty much police have always told us where they're going.
Yeah, you're absolutely right, Gail, because police are held to a lower standard than DMH, really. Okay, so they'll even you know, broadcast it over the radio. You know, follow up to Los Angeles Hospital or wherever. So yeah, it's kind of a public knowledge.
Mhm.
Yeah, but
Okay.
yeah, they're held to a lower standard than we are in DMH.
Oh, okay.
When I work, I just got off from Los Encinas. When I work at Los Encinas, what I have to do is, you know, families will call, you know, asking if their loved one is there. And what I do is I have to call the unit and, you know, say, ask the patient directly, you know, do you want your loved one to have the access code? And if they say, hell no, I have to go back to the family and say, you know, try again tomorrow. You know, the family knows they're there, but they want to talk to the social worker or the psychiatrist. You know, it's hard, but I always tell families, you know, call tomorrow. Maybe there will be a change of heart. You know, I feel always bad about that. You know, because I'm a mother too, and you know, they want the best for their child, but you know,
Right. Right. You're talking about LPS and under that 5358.5, having the person put in. But when a
yeah.
person is not under the LPS conservatorship, we talked about that the other night.
5150.05, credible
Yeah,
collateral. Yeah.
right.
Credible
If you can
collateral.
talk
I use it quite
that,
often.
right. And what you had told me the other day when the police being able to go in when the person won't open the door. Can you talk about that?
Sure. So that's a hard situation. We get calls where families call and we door knock. We usually start out like with a welfare check. So we go out, knock on the door, and person doesn't answer. Okay, then I just went on one the other day. So with the senior lead officer. So it's a long gated driveway. There's a call box, right? We call and no answer, and then we call the patient on his cell phone, and he says he's not there. And what can we do? We pretty much believe he was there, but it's a long driveway and we can't go up the driveway. The gate is not opening. So unless somebody opens the door for us, we have no choice. If there's somebody in there, that's why we like to have, when we go out, if a family member is calling, can you meet us there, enter wherever the person is, and open the door for us? Then we can go in. Or say if somebody is the owner of the property and they have a key and they open it. I've had recently, I had a apartment manager, when it got to the point, only when it got to the point where the sister was so concerned because her sister wasn't answering the door, uh, only then the manager of the apartment decided it was exigent circumstances because maybe she could be dead in there or something. And the sister was convinced she was in there. And unusual for her not answering the door. So the apartment manager went in, opened the door for us, and actually she was not in there. And she ended up being fine, and we found her and actually hospitalized her. But she had gone somewhere, but to the airport actually. But anyway, only under exigent circumstances can we actually go in.
Okay.
Any other questions? But I'm really happy about what's going on, Gail, with the senior lead officers, and they're doing really good work in all the police divisions in LAPD, going to roll call after roll call, and um, spreading that information about conserved patients.
That is the best thing they could do because
Mhm.
It's so good. Yeah, I'm
Yep.
very happy that they're really taking a proactive approach to that, and they get it. Okay, now we just have to make the divisions get it. They're going to all the roll calls, so that's our new.
that
Yeah.
is really
Mhm.
monumental.
Mhm.
The other thing that we need is for the police to be willing to put hands. Can you discuss that? Hands on a person, even though the person's not conserved, but to do a 5150, because
So
that's
yeah.
the most seriously ill
Yeah,
person.
Linda remembers that back in the day, LAPD was really good about
Absolutely.
doing that. The sheriffs were not so good, but recently, like during the pandemic, all these uses of force that they got involved in, things have changed, and you've got these new officers. All the old school officers, they still kind of do it. They do it, and and like Linda said earlier, it's not that they don't want to help. It's like they can't because they're so afraid of uses of force. And if you look at all the not all, but the uses of force, they're with our patients. And I remember one thing you said, Linda. I remember a lot of things you said, Linda, but a lot of things. But one thing Linda said after the SWAT call out when Randy Simmons was
Mhm.
killed, Linda said, and it always breaks my heart to hear it. Linda said that I always felt bad because it was one of ours. It was a mentally ill patient that that killed Randy Simmons. So almost like a sense of guilt that why couldn't we do something with him, the patient I'm talking about. So yeah, it's all. Don't you agree, Linda? It's pretty much
Yeah.
getting worse.
So I think two things. One is to go back to the slows for a second. We use the slows and we use ramp with when we're doing it in sheriff's territories. But when we're instituting those hospitalization orders with the court with AOT, we coordinate. If it's in LAPD's jurisdiction, we coordinate with the slows and we set up a whole way of doing it so that there's collaboration. We put the order out for a couple of weeks so they gather the information they need so that everything is safe. We often do it, they want to do it at like 6 in the morning before the person really kind of wakes up, so that there's no need for any kind of use of force or any of those things. And I
What
think,
is-
Dee Dee's right
what-
back in, go ahead.
What is SLOS and RAM?
Senior lead officers, or the officers,
Okay.
Dee Dee, they're the SMOT camp officers who've now become I think every division has regular senior lead officers who are sort of working in the community, working with community members. These senior lead officers are specifically the mental health senior lead officers out
Oh,
of MEU campus. So then, back in the day, even the psychiatric mobile crisis response teams, I'm old enough to remember when we would put our hands on clients and where we would, we would help get the person on the gurney. Then the department DMH went through a series where we couldn't put hands on anymore. And now, because of the lack of the police assisting, the policy now in Department of Mental Health has changed, where we now when we feel safe, can put hands on a person to help them get on the gurney, and we have specialized training for that. But I think the advent of cell phones, and people taking pictures of everything, it changed after George Floyd. It got worse. They did change the law in California, but nobody can give me the new law where it says that law enforcement's more responsible. And I was thinking, sort of in response to what you said earlier, Gail, I think it's a really fine line that we're all trying to straddle. On the one hand, we want law enforcement to help us safely get people on the gurney, because I can tell you, and Dee Dee can as well, in the Department of Mental Health and with our full service partnerships, our contracted programs, anyone who's in the field doing 5150s has to walk away every single day, sometimes multiple times a day, from people that they know meet criteria. They cannot get that person on the gurney, and the police will not assist. So another thing that interferes is, when you think about it, any use of force. So if I grab your wrist and I twist it a little, that's a wrist twist lock the police use to gain compliance. That is now considered a use of force. You have too many uses of force in your police packet, right, in your file, that inhibits promotions. That inhibits advancements in lots of different ways. So police are acutely aware. And also, with citizens looking at them, they may not interpret the situation the way it's really happening. So what they see is the policeman's grabbing somebody by the arm, but they don't see what led up to it. They don't hear the conversation. So then they start to present it in a totally different way. And I think we need to be very careful about on the one hand, we want police to be able to help us without getting those repercussions. We want them to be treated fairly as well. On the other hand, we do know that often folks who have a mental illness can die at the hands of police. And so we want some laws to help control that, while still assisting police who are acting appropriately to assist getting a person to the hospital. And most of the time, police are acting appropriately. So the outliers are the times that police do end up shooting someone, and we hear about those a lot. We don't hear about the millions of times every day law enforcement helps and helps us do what we need to do. So it's a fine line getting something that allows them to, on the one hand, act in an appropriate, helpful manner to assist the person to get the help they need. And then on the other hand, when some folks respond too quickly and the client gets injured. And Dee Dee, I know you wanted to say something. Sorry.
No, I'm good. I'm listening to you. No, nothing at all. I'm agreeing with you.
Yeah. What can we do? I mean, the people listening to y'all right now, what can we do to change it so that the police are not held, so that they can go ahead and help us to get the person on the gurney? Because it's the most serious ones, the ones that are danger to self and others, that refuse to go. And we really need to get them in treatment so that they have a life again. What can we do politically, advocating? Any suggestions?
Well, I think that, Chief Moore, he's no longer going to be there, right? But
Mhm.
he was a big proponent of mental health, and I think that he really gets it. But you've got like I said, you've got these new officers. They're afraid of their own shadow because of what's happened. And
Right.
Linda's right, like the whole George Floyd thing and all this. They're like, oh, they'd rather just disengage. That's the buzzword than help these people. I think that educating some of these newer officers, especially, they talk about it all the time in our roll calls, Linda, about the new officers. They're afraid. They're afraid because they're new. They're afraid they're going to get in trouble if something goes down. Because like I said, it can go down. Some bad thing can go down. Look at this kid that had the fork in his hand, and it just so happened they shot him. Okay, and the family is saying he was mentally ill and da 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 da. And that whole career is ruined. And I mean, I don't know. I didn't see the whole video, but it's just then then another thing is the video camera there, it's like all out there now, besides the cameras all over our city. Those video cameras, I mean, something that could look like, a horrible thing maybe was, something they had to do or something like that, so.
I know, like,
I'm sorry, I think what we do is, so when the crisis teams are out there without not talking about the law enforcement co-response models, I think they have a little more luck or success because the officer on the SMART team is talking to the patrol officer, and officers listen to officers. So that's been, I think, a great help. And many, like I said, 39 jurisdictions have teams. Some are called MET, one's called HOPE, the rest, and most of them are called MET. One's called HOPE, and then LAPD is called SMART. When our mobile crisis teams are out there by themselves, we will ask, please, ask the officers for their names and badge numbers so we can put them in our records. So if something happens to this client, we'll know who to tell the family to call. We've tried that. We talk to the watch commander and explain the situation to the watch commander. Oftentimes they'll call a sergeant out to the field. And sometimes the sergeants will say, no, we're not putting hands on, even sometimes when the officers want to, but just as a part of protocol or to be doubly sure, they call a supervisor. And sometimes the supervisors will say, yes, we understand. Articulating to law enforcement exactly what the client is doing, why you feel they're a danger, why you feel they need hospitalization, may sometimes help. And Dee Dee's right that a lot of the more experienced officers will, because they know that they can put the hand on the person's elbow and get them onto the gurney, that they're not going to have to use any kind of excessive force. Many of the officers will spend a long time trying to talk to the person to get them on the gurney.
And the older officers, the senior officers, know that this is not going away. It's just going to generate another call. Okay, so let's just handle it now because we're going to end up handling it.
Right. And the other thing I think is the NAMI being active politically. NAMI. So when we did the court orders for the hospitalizations for AOT, at the time, Brian Bixler was the lieutenant over.
Yay, Brian.
Yeah, yay,
Yeah.
Brian.
Yeah.
Over the mental health unit with LAPD. And John, I forgot John's last name all of a sudden, was the lieutenant over the sheriffs, which are the two largest agencies in LA County, and they both have mental health law enforcement teams. And they, we called them in together with the judge, and they determined the terminology to be used on the court order. So that was a law enforcement verbiage that is put using reasonably objective force to execute the order. So I think bringing police on board through the Chiefs of Police Association, maybe NAMI could go to the, LA County has a Chief of Police Association where the chiefs from all of the jurisdictions in LA County meet. And it could be in other counties too, but I'm speaking specifically of what we have, and maybe present to them the difficulties of how, and you know, and folks who are having an episode, as Dee Dee's mentioned, and we've all mentioned, it tends to not always get better. The other thing that I get concerned about, I think other folks do too, is that the more we call police and police come out and we can't execute the 5150, it empowers the client to say, see, there's nothing you can do
Yeah, I
to
agree.
make me change my
I
behavior.
agree.
And so the more we do that, it more reinforces, and they already don't believe they have a mental illness in many cases, and there's been a lot in the chat about that. And we just are empowering the illness or the delusions or whatever is going on for the client to feel they don't have to comply with anything because look, even the police won't
Even
do
the police
anything.
won't do anything.
Right.
Yeah.
Right.
Mhm.
You know, though, to to the law enforcement's credit, there's more of a effort to train their police officers properly now. I think there's a big movement right now to address the mental health conditions and guide their police officers on how it's not easy to engage somebody who's dealing with a psychotic episode. You know, so police are traditionally trained to deal with force issues. You know, and I think now there's a big movement within many law enforcement agencies to train their officers correctly when dealing with somebody with mental illness. So I think
Well,
that's
we
a
have
very
a,
positive thing.
yeah, at Smart Team, we have a MHIT. It's called the Mental Intervention Training. And all officers are required, it's a 5-day training, 4-day, and they're required to go through that. And we actually bring NAMI in, we bring people from the Alzheimer's Society, different people to present to the officers, you know, how they're suffering and dealing with these kind of issues with patients.
And often clients, we used to bring
Sensitize them.
clients. Right. We used to bring
Yeah.
clients in as well. And in other jurisdictions, it may be called crisis intervention training, the crisis intervention teams, the Memphis model. Someone in the chat asked, and I think we can address lots of questions, but someone in the chat asked about Proposition 1. So let me say a little bit about Proposition 1, which is on the March 5th ballot. Our Board of Supervisors has not taken a stand on Proposition 1. So I cannot give you an opinion. We, Luis, Dee Dee, and I may have opinions. We cannot give you our opinions about Proposition 1, but let me just say what we know about Proposition 1. So the Mental Health Services Act Mental Health Services Act was passed, Prop 63 was passed in 2004, which taxed millionaires 1% to be given to county mental health departments to provide treatments, mostly voluntary treatment, and to provide new forms of treatment for folks who have a mental illness. Proposition 1 looks at that money. So up till now, counties have had the ability to spend that money on the clients in ways they feel best support the clients. So right now, the way my understanding is with Proposition 1, we have prevention and early intervention money through Prop 63. 51% was to be spent on children. The state is taking that prevention money back. So training staff, any kind of prevention activities is going to be done through the state, not through the individual counties. So that's one piece that the state is taking back. The rest of the Mental Health Services Act money is going to be divided into 3 pots. And if I'm wrong, Luis and Dee Dee, correct me. So 30% is for housing only. So brick and mortar houses, not any supportive. That doesn't talk about any mental health treatment in facilities, putting in any kind of staff in mental health facilities. It's not talk. We all have permanent supportive housing where there are case managers, therapists, people in the actual facility who can provide those things to help the clients in those facilities to continue to do well. So 30% is for the housing only, just the brick and mortar. Sorry, 35% is for full service partnerships. So that will increase our ability for full service partnerships. Sorry.